Ladies and gentlemen, dear FIDE friends, a very good morning to you all. FIDE back again in the tail of the pandemic with an in-person meeting of minds, different generations, new ideas, a gathering of some of the keenest jurists in European law, debating and discussing the state of art and prospects of very societal relevant topics of EU law. The last days flew by, and now already, early 9 o'clock, the final day of FIDE 2021 in The Hague commences. On behalf of the FIDE board, I have the honor to give the floor to our excellent general rapporteurs, acting general rapporteurs, to reflect on the working groups, round tables, and our moderator of this session, Judge and Professor Sascha Pregal, who has been an ardent supporter of our Congress. From the somewhat peculiar, wild idea to get FIDE organized again in the Netherlands for a third time in history. All kinds of issues she assisted and advised us along the long and bumpy road of the last 9 years. To her willingness to rise and shine and moderate the following session on 9 a.m. Saturday morning with a sense of happiness and a sparkling smile on her face. Please your attention for Sascha, Anna, Orla, and Peter. Thank you.
You see, I'm such an ardent supporter of the FIDE that they even got it done to get me here at 9 o'clock. And I'm not the person who is, well, very happy until 11. I'm a bit shy, in fact. So, but anyhow, welcome, of course, to the beginning of the end, in a way. So the last part of this long-awaited FIDE Congress. It required from the organizers a lot of patience, flexibility, perseverance, and inventiveness. And there are organizers here. Yes, you have done a wonderful job. Thank you. Now, during a 1.5 day, the working groups have been discussing themes which, although chosen quite some time ago, it must be 3.5 or 4 years, perhaps even, those themes proven still topical and highly relevant. Some of them perhaps even more relevant nowadays than 3.5 years ago. And I have now the pleasure to introduce very briefly the general rapporteurs and invite them to brief us on the discussions that took place in their sessions. So the acting general rapporteur for topic 1, the national courts and the enforcement of union law, is Anna Wallerman, associated professor of European law at the Gothenburg University. She is a very experienced researcher with interest in EU constitutional, institutional law, in judicial procedures, including the access to justice and the preliminary procedure. Please, the floor is yours.
Thank you. Good morning. And let me first join Sascha in thanking the organizers for this wonderful event. It's been a real success, so congratulations. And also thank you for entrusting me with being the acting general rapporteur for topic 1 in Michael Dogan's absence. I know that Michael Dogan would really have liked to be here, and I would like to acknowledge his immense work as well in putting together the questionnaire and the general report. Now, engaging with the discussions over these last 2 days have been a real pleasure and a privilege, but at times also a little bit challenging. The task for this morning is different. This is not challenging. This is actually impossible. I'm actually being asked to summarize 2 days of vivid discussions on questions that are of fundamental, not to say existential, importance for the European Union in 12 minutes. So this will be a failure. This will be a failure to capture the richness of the debates and the insights that we have been treated to. But nevertheless, I will give it a try. And following the advice of Professor Paul Craig, rather than the example of Michael Bobek, I will do it in an even number of observations, namely 4. So the first observation concerns the relationship between EU law and fundamental rights, so the classical themes of supremacy and direct effect. Recent case law from the Court of Justice has upgraded, I might say, fundamental rights within the EU legal order by recognizing the direct horizontal effect of the Charter and by accepting that substantive EU law can be balanced against the need for respect for fundamental rights, for instance, in the well-known Tarico 1 and 2 cases. And we agreed in the discussions in our panel that this balancing exercise is inherent in the interpretation and application of law and could perhaps be seen as a sign of maturity, of a new step in EU legal development. And we agreed also that this is actually not a concession, it's not a limitation to the principle of the primacy of EU law, but it's rather a weighing of competing interests within EU law, where fundamental rights set a limit to the reach of substantive EU law obligations. Nevertheless, we also observed that this perspective is not quite shared by the member states. And we noted 3.5 cases of recent challenges against the primacy of EU law, coming from courts in the Czech Republic, Denmark, Germany, and most recently, but also less confrontatively, that's the half case from France. And we noticed that the Court's new case law on balancing EU law effectiveness with EU law fundamental rights and general principles does not seem to have gone all the way in helping these national courts to reconcile their duties under EU law with their commitment to what they clearly perceive to be higher values. We also noted that there are still quite few examples in the member states of the Charter being applied horizontally between in disputes between individuals. And we discussed the possible reasons for this. We highlighted that horizontal fundamental rights protection is actually a foreign concept to several member states. And we also noted that there is still a certain unfamiliarity among national judges with the Charter of Fundamental Rights, whereas the national bills of rights and the European Convention of Human Rights would be more familiar to most. And in light of these observations, we raised the question whether the Charter actually has an added value or whether it might be a pragmatic solution if reliance on national standards actually leads to similar results and is more convenient for the national courts, whether a sort of don't ask, don't tell policy could be a pragmatic solution going forward. But there were also voices in the room that advocated for a more orthodox insistence on the principle of supremacy. Second observation concerned the ongoing rule of law crisis, which was a recurring theme in several of the sessions in topic 1. The national reports showed that most member states, I would say, have some concerns regarding the judicial independence and a fair trial. But we we decided that these must be seen on a scale from the not perfect, because nothing, of course, is, but from the generally satisfactory member state legal orders over gradually more troubling developments, and on in the other extreme to the systemic breakdown of judicial independence. And we also noted the worrying possibility that this scale is actually a slide where smaller problems might escalate into more serious problems. We agreed that at some point on this scale, a problem ceases to be a purely internal member state concern and instead becomes a common union concern that we need to address from a union perspective. But we unfortunately found it difficult to pinpoint exactly where to draw that line. And we also noticed that it is not easy to identify what the appropriate union response might be to these problems. We discussed the notion of judicial independence that appears in Article 19 of the Treaty on the EU, Article 47 of the Charter, and Article 267 of the Functioning Treaty. And we argued that even though this same concept reappears in all three articles, there might be a case for recognizing that the three articles have three different functions, which might justify a different standard of scrutiny under each of the articles in the different circumstances where they arise. But then what are the standards that we should apply? Here we had different voices in the room, some that advocated a hard line, preventing offending member states from participating in those initiatives that require mutual trust, most notably the European arrest warrant. But we also had the perspective that excluding anyone might actually make the situation worse for the many judges that still strive to uphold the rule of law and increase the risk of rights violation for the general population. And we observed the risk that the cure could be worse than the disease if the Union abandons its own standards in its eagerness to counter the rights violations and the problems that we see within some member states. So frustrating as it might seem, the EU's long-term interest might not always coincide with the needs or wishes of the member states concerned. And I do not envy the court the task of balancing, on the one hand, the wish to provide support to the Polish judges, which I think is evident in the court's case law, but on the other hand, upholding the rule of law within the EU, which necessarily includes staying within the limits of that law, even when that prevents a greater show of solidarity. And that brings me on to the third observation, which concerned the role of the judiciary and the division of that role between the Court of Justice and the courts of the member states. Now, as for the courts in relation to the other institutions, we observed that the Court of Justice has taken on a large and important role, and perhaps a role that has become larger than is necessarily desirable. The court has stepped up and become one of the major players. But we observed that both legislative and executive support is needed. We observed concerning the rule of law crisis that the court cannot take a firm stance or fill the gaps that are created by failing rule of law standards without legislative support. And we addressed another ongoing crisis, namely the climate crisis. And we noted that there is a growing trend of bringing questions that perhaps should belong in the political domain to the courts. Also, again, noting a need for legislative intervention to ensure the appropriate forms of access to environmental and climate justice. And we also were reminded that, of course, the court is dependent on the executive and the member states for enforcement of its rulings. When it comes to the division of the role between the member state courts and the Court of Justice, our discussions centered on the preliminary reference procedure. Of course, recently in the Consortio case, the Court of Justice has reaffirmed, albeit with some important clarifications, its relatively restrictive shell-fit approach to the exceptions on the obligation to refer of highest national courts under Article 267, subsection 3. And we noted that this reaffirmed stance by the court seems to stand in some contrast to the prevailing interpretation of the acte de claire exception within the member states, where member states seem to consider this a more lenient exception that can be invoked more easily than perhaps the court's case law would require. In our discussions, we underlined the need for open communication between referring courts and the Court of Justice, while the discussion also illustrated the Court of Justice's continued commitment to ensuring judicial protection in a wide range of cases, thus resisting calls from some commentators of taking a more selective approach and going towards becoming a court of precedence. Finally, my last observation, and my shortest observation, I will assure you, concerns the principle of mutual trust and recognition, where our discussions were a precursor to the topic 1 of the upcoming FIDE Congress in 2023. And our discussions were focused mainly on the European arrest warrant, and this was perhaps a topic where the disagreements within the room were largest, which bodes well for the continued discussions. We had voices in the room arguing that there is too little room for refusal to recognize foreign rulings in the face of systemic rule of law violations. But we also had voices arguing that it's actually too easy to refuse mutual recognition, at the risk of creating safe havens for criminals and not respecting the rights of victims of crimes. It was underlined that the exceptions to mutual recognition should remain exceptional, but it was also argued that in the face of serious problems in a member state, it will be easier to satisfy the test for exceptions. So I think the one conclusion we can draw is that there will be fruitful discussions to be had when we reconvene in Sofia. Thank you.
Thank you, Anna, for doing the impossible. You've done very well. I move immediately to the second topic, the new data protection regime. And here the General Rapporteur is Orla Linsky, Associate Professor of Law at the London School of Economics. Her expertise and research interest is in the field, you will not be surprised, of data protection, digital rights, technology regulation, and EU law. Please, Orla.
Thank you, and good morning, everyone. I think following on from Anna's introduction, I'm very glad these sessions were recorded, although I was initially skeptical when I heard this. So for natural reasons, before beginning with some substantive remarks, I want to say, first of all, what a privilege it has been to act as General Rapporteur for this topic at FIDE. So to thank the FIDE committee for inviting me, and also to thank Jorrit Rietema, who has masterfully steered me through this process from the drafting of the questionnaire to the discussion this morning. Personally, as an Irish woman in the UK, and in particular as an EU lawyer in the UK, this has been a valuable kind of personal opportunity to engage with EU colleagues. But I've also learned a lot from this experience professionally. So I want to thank the National Rapporteur for the very detailed, meticulous reports that they compiled, ranging from topics covered by courts to the national data protection authorities to the legislature in what is an evolving and kind of dynamic field. So I really appreciate the time, effort, and attention to detail that went into those national reports, which really made my job quite easy. I also want to thank the two institutional rapporteurs, Anna Buchta from the European Data Protection Supervisor's Office and Herke Kranenberg from the Legal Service at the Commission, who I would describe as a kind of an institutional dream team when it comes to this topic, because they really covered the jurisprudence, the underlying concepts, but also this rapidly evolving policy environment. So kind of that being said, that the topic we were asked to discuss was the new EU data protection regime. But I want to start this morning by emphasising that data protection in Europe is not new. We've had laws at EU level since 1995 with the 1995 directive. And I think if you go to the national reports, what was welcome to see from my perspective was that the core concepts that you find in data protection law, so you see these in Article 5 of the GDPR, but they were also there in the Data Protection Directive before, so things like purpose limitation, data minimization, data security, core international concepts, are now very well embedded at national level. And even the kind of more ephemeral concepts that you find in that Article 5 of the GDPR, so things like fair data processing, have in fact been interpreted and applied in the decisional practice of data protection authorities across Europe. The second thing to note is that at EU level, the European Union is unique in codifying the right to data protection as a distinct right from the right to respect for private life in the EU Charter. And internationally, the reception to this kind of distinction between privacy and data protection is often contested. So we see that it is often advocated, not in the case law of the court, but elsewhere, that data protection is simply a subset of the right to respect for private life. However, again, from the national reports, what you can see is that although I wouldn't kind of describe it as a common constitutional tradition insofar as member states have differing starting points for introducing or having data protection as a constitutional right, there are in fact a number of EU member states that already have constitutional rights to data protection. And so, again, it's kind of welcome to see this reflected at European level. This being said, this FIDE conference provided a first opportunity to look at the way in which the General Data Protection Regulation, which entered into force in May 2018, the way in which that regulation has been received at national level. So one thing to note about the GDPR is that although it is a regulation, it leaves considerable scope for its, I hesitate to say implementation, but its reception at national level, insofar as it makes numerous references to national law, allowing national law to either expand on its provisions or to introduce exceptions to its provisions. So with that in mind, I think in the conference we sought to cover some topics which were addressed in the national reports, but also some topics which had emerged as important in the intervening period. And I think that three key themes emerged from our 6 panels. So the first theme, and I think this echoes a little bit what Anna has been saying, was about the reconciliation of data protection as a charter right with other rights and interests in the EU legal order. So in the national reports and in the questionnaire, I had asked about the right to freedom of expression and data protection on the back of the well-known Google Spain jurisprudence. But here we discussed this in the context of the pandemic, where we saw a real first test case for the GDPR at national level when it came to reconciling the right to data protection with the very tangible interest of states in responding to a public health crisis. And here what you could see was that data protection in some ways became one of the main legislative instruments in focus at national level as states reached for various technological solutions in order to tackle the pandemic. Some rightly, some wrongly, but I'm sure you can all think of examples ranging from contact tracing to the COVID certification we provide at the door when we enter this morning. And so data protection authorities found themselves at the front line in this response, led, I would say, by the European Data Protection Supervisor, which produced an incredible amount of guidance for to steer the member states through this situation. I think the key takeaway from our session was that GDPR proved itself to be a flexible instrument insofar as it didn't hinder the member states' response to the pandemic by limiting, for instance, the use of data for epidemiological reasons or for others. Rather, what it did was ensure that when personal data were processed by the states in their response, that this was subject to the safeguards that we find in Article 5. So it provided that kind of flexible data governance framework. So this is a great illustration, or rebuttal, I guess, of the claim that GDPR is a limit on innovation or is a limit on the way in which we use technologies. It simply influences or shapes the use of technologies in a way that makes them compliant or compatible with fundamental rights. We also discussed the interaction between data protection and national security. So here, there's a thicket of case law that I'm sure you may be aware of, starting with Digital Rights Ireland, a case of constitutional significance, going into Tele2 Sverige, where the Court of Justice found that mass and indiscriminate data retention for the purposes of fighting serious crime was incompatible with the EU Charter rights to data protection. So in the national reports, you see immediately the diverse responses to this judgment at national level, if I could diplomatically put it that way. We discussed the emerging case law before the Court of Justice, in particular the most recent case in Le Quadrature du Net, where there was consideration of how this case law applies in the national security context as opposed to the criminal context. We queried the practical plausibility of distinguishing in very categorical terms between national security, serious crime, and ordinary crime, taking examples such as the pending reference from France, where the claim is made that the destabilization of a financial system could in itself lead to public order issues or national security issues, and queried the role here for the margin of appreciation of the member states and what flexibility remains in the case law. And I'm sure we'll learn more about that in answers to pending case law. A second theme was data protection in its broader context. Here we discussed the broader global context, but also the broader regulatory context. So I think it's safe to say when we spoke about the broader context, we had an animated discussion. We considered the impact of the court's case law on transnational data flows. And in particular, I began this discussion by querying whether or not we could look at the impact of this case law as one of data localization, with the objective, of course, of ensuring that European fundamental rights are not undermined or circumvented when data is transferred from within the EU to outside of the EU. More moderate colleagues said that we couldn't look at the case law as data localization case law. Instead, we should look for the margin for manoeuvre that remains for data transfers within the case law in a way that remains compatible with fundamental rights. I think all in the room were agreed that there is need for some evidence regarding claims made about the economic impact of data flows, whether that might be the damage as a result of limiting data flows, or the potential benefits from a European perspective to concentrating data flows within the EU. We also then discussed the broader regulatory context in which data protection sits. So here, since November of last year, we have had proposals for a Digital Services Act, a Digital Markets Act, a Data Governance Act, an AI Act. We obviously didn't go into detail on all of these legislative proposals, but it was noted that each of these proposals is without prejudice to the GDPR. We queried whether this is putting a little too much back on the GDPR to resolve eventual conflicts or incoherencies between these legislative measures, a role that will ultimately fall to the court. But noted the advantage of this, which means that this legislation must now be interpreted in light of the EU Charter rights to data protection and to privacy. On that, we spoke a little bit about one example in particular, the notion of data altruism that you find in the Data Governance Act. And so this is the proposal of the European Commission to encourage European citizens to volunteer their personal data or non-personal data for the public good. So a kind of a noble initiative, no doubt, but we queried how that sits with principles of consent found in the GDPR, but also of notions of purpose limitation, for instance. The data collected for one purpose shouldn't be repurposed for another incompatible reason. I also think this raises issues around data quality. Who will volunteer their data? Will we be able to make decisions on the basis of a data set that is partial, that includes the data of only those who are confident enough to give their data, who will be invisible in this context if we use or develop our AI systems on the basis of this type of data set. And interestingly, in the AI Act, you find a requirement that data sets must be complete and robust, and this seems to me at odds with provisions in the Data Governance Act. So the panel concluded with the call for coherence between these regulatory measures. Finally, we spoke about enforcement. So here, by and large, if you look at national level, since the adoption of the general report to us being here today, we've had over 600 decisions by national data protection authorities applying the GDPR. So enforcement is working well at national level. However, the GDPR also introduced a new, I would say, experimental governance framework at EU level, the so-called one-stop shop. And here, the essence of the one-stop shop is that where a company has a transnational or trans-European presence, so you might think here of the big tech companies, for example, the primary authority responsible for dealing with that company is the lead authority that in the place of their main establishment. As you are no doubt aware, the place of main establishment of many of the big tech companies in Europe is concentrated in a few member states. And this leads to practical and legal impediments to the operation of the one-stop shop. So what we're seeing is a backlog in cases as a result of this decentralized system. So we discussed some of the risks of this, the risk of forum shopping, the risk of regulatory overload or overburdening of some data protection authorities. We also discussed mechanisms within the existing structure to deal with this. So we queried whether or not it was compatible with fundamental rights for data protection authorities to engage in a kind of strategic selectivity of the cases that they deal with. And I think it followed from the national reports that that is already common practice at member state level. But I think there was also a certain amount of regret expressed in the room that the system doesn't have a centralized component that enables the one-stop shop to be circumvented where it is not functioning correctly, or as an alternative, perhaps, to the one-stop shop. We also then discussed, beyond national data protection authorities in another panel, the role of other actors. And here we could think of private enforcement, civil society role, which has obviously been very significant in this area, if you think of Schrems and also the Digital Rights Ireland cases, but also the role of other regulatory authorities, competition authorities, financial services authorities. And the moderator for this panel asked the very basic but important question: have these actors helped in the development of data protection in the EU to date? Or has their role led to a hindering of harmonisation and effectiveness? Here, I would say it's probably too early to say. We have case law pending before the court regarding the interaction between regulatory authorities in this area. But there's probably a lot to be learned by data protection law from other areas of law, EU law, where we have this kind of multi-layered governance system already in place. So it's probably time for data protection lawyers to look to colleagues in competition law and elsewhere to see how these types of jurisdictional and regulatory conflicts are resolved. So I'll conclude there.
Your time is almost up. Okay.
So to conclude, I concluded with the very uninspirational comment at the beginning or at the end of Thursday that this is complicated. I would conclude today by saying this is complicated, but as you may have gathered, extremely important. Data protection is a cornerstone for the use of data in a digital society. So as we've seen in the pandemic, important to us at a very personal level, but also it will be the regulation and the charter right that informs the regulatory policy that the EU is developing for digital more generally.
Thank you very much, Orla. And I turn... Immediately I turn to Peter van Kleinenbreugel, General Rapporteur of the third topic, EU competition law and digital economy. Peter is Professor of EU substantive law at the University of Liège, and his research focuses on the internal market, competition law, and also the administrative and judicial enforcement of union law in the member states. So perhaps you should talk to Orla. She can learn about how to enforce data protection, okay? Floor is yours.
Thank you very much. Greetings from the second floor, ladies and gentlemen. We have been in the same building, but we have been on a different floor, so we had quite a few interesting discussions on competition law and the digital economy. Just to give you a flavor of the amount and the diversity of questions that have been raised and have been debated but not been answered conclusively in the absence of case law by the EU courts on the matter, just a brief overview. Is simply having gathered data or being able to gather large amounts of data, is that in itself an indication of being able to impose barriers to entry? And is that in itself a sign of having a dominant position, creating, under Article 102 of the TFEU, a special responsibility not to abuse that position? If that is the case, is refusing access to your data set abusive? And could competition authorities force you, require you, ask you, recommend you to give access to certain kinds of data? If so, in what form? And respecting GDPR conditions, yes or no? What happens if two competing businesses, undertakings as we call them in EU competition law, decide to, independently from each other, buy a self-learning algorithm that engages in price signaling or that sets prices without any direct human intervention, but that results in two businesses, two undertakings tacitly imposing or proposing the same price, so colluding potentially on prices? Is that behavior covered by the current interpretation of Article 101 of the Treaty on the Functioning of the European Union? A vivid debate has been held in our working group on whether or not that is the case, and we don't have a final answer, even though we are inclined to say no at this stage. Do we need specific rules for online sales? Do block exemption regulations need to be adapted to include, to reflect the specificities of online sales? Some work is being done, important work is being done at this stage at Commission level with the update of the vertical block exemption regulation. Update, questions, open debates. Indeed, we are in a somewhat speculative domain at this stage. A lot is happening. No one can deny that the digital economy influences our lives. We shop online, we make use of algorithmic technologies, and we all realize that competition law can play a role in ensuring correct behavior of businesses engaged in the online world. But should competition rules be interpreted differently? Could the existing competition rules be applied with some tweaks and modifications, modified interpretations to the online world, or is a more fundamental rearrangement of regulatory relationships necessary? The starting point of our reflection was that, of course, Articles 101, 102, and even the concentration control regulation, the hardcore of EU, and apologies for using the American word, antitrust law, is indeed rather stable. Is there and has been there since the early days. 101 and 102 are EU constitutional law. European Union has constitutionalized competition law provisions. Those provisions, as our institutional rapporteur eloquently said, apply to bananas, washing machines, but also to data. And indeed, those provisions are sufficiently open-ended, are sufficiently wide to cover all kinds of business behavior. Nevertheless, that being said, those provisions need to be applied in specific economic, specific market circumstances. And in the digital economy, quite a number of questions were raised. And I have identified 3 sets of questions that have come up throughout our discussions. The first set of questions deals with gaps and challenges the current legal framework poses. The second set of questions deals with EU competition law against the background of a changing regulatory landscape. Regulation is being imposed increasingly not only in terms of data protection, but with the current proposal for a Digital Markets Act, there's also going to be fundamental, if the act is adopted as a regulation in its proposed form, is going to fundamentally change, that's at least what we came out, or what came out of the discussion, is potentially going to fundamentally change the relationship that traditionally exists between competition law and regulation, that is one of complementarity. Traditionally, the court has said, in cases such as Deutsche Telekom in electronic communications, that competition law and sector-specific regulation are complementary, can be applied next to one another. Is that also the case in digital environments? And the third element, a more transversal element that came forward in our discussions, is the question, where is competition law headed to? We have seen a tendency towards a more economic approach in the interpretation and application of EU competition law. More economic approach is a notion that, in my opinion, has been abused to a certain extent to say, look, the law is less relevant. That's an incorrect assumption. But in our debates, the question popped up, are we engaged in a more economic, or are we changing from a more economic to a more legal approach with regulation added to competition law? And what's the impact on competition law enforcement? I'm looking at the time is running out fast, but I would like to give one example for each of the 3 so that you have an idea. If not, I guess we were recorded, so please go and watch us, go listen to us if you feel now that you have missed something in terms of competition law. I always say to my students, les absents ont toujours tort. Those absent are wrong. But in this case, given that there was so much other interesting discussions going on, I completely understand any absence. Well, I have nothing to say about that. Anyway, I stop in this way. I'm not going that far. Anyway, let's talk about gaps and challenges. In terms of gaps and challenges, we identified an important gap, for instance, in the notion of tacit collusion, as I already said in my introduction, but also in the construction of the market definition framework. Market definition by the European Commission is organized around a communication of 1997, which is currently in the process of being updated. In that update, indeed, attention to digital markets is paid, and we are going to have to see how that works in practice and how cases before the court, when that issue comes up, will be validated or not, or whether the court will intervene in that discussion. Another challenge in the context of the digital economy is the remedial challenge. What kind of remedies can competition authorities impose? What kind of remedies can the European Commission impose by way of interim measures, by way of behavioral structural remedies? And how is judicial review going to be organized over those remedial decisions? An open question that has been given some answers, but I'm just flagging the question for your attention at this stage. Regulation and competition law. There, of course, we have had quite interesting debates on what we have called the elephant in the room, the Digital Markets Act, which is adding an important layer of regulation to traditional ex-post competition law enforcement. Ex-ante regulatory obligations inspired by competition law infringements. That is not something new that has happened before in other fields of EU regulation as well. But what struck us is the proximity between the regulatory obligations the DMA would impose and the general prohibitions under EU competition law. Can we still say that this ex-ante regulation protects different interests from competition law? And if that is the case, perfectly fine. But if that's not the case, are we then dealing with sui generis competition law provisions, more detailed regulatory competition law provisions? If that's the case, there are implications from a procedural, institutional, fundamental rights perspective as well. Non bis in idem, which is currently, of course, before the court in the bpost and Noordzucker case. How will that play out in the context of digital markets? The powers of national competition authorities, if DMA enforcement is similar or the same as competition law, what can the German Bundeskartellamt do under its new Section 19a of its German Competition Act? Those questions have been raised and we have discussed them, and there were differences in opinion, but absent final cases or judgments on the matter, we don't have a final answer. We have our ideas, we have agreed to a certain extent to disagree on certain issues, but it shows that those issues are, in our opinion, and in my opinion certainly, going to come before the courts in the years to come. So also a brief note to the organizers. It has been evoked on multiple panels that in 10 years' time from now there should probably be a new FIDE session on EU competition law and the digital economy. My final observation is about a rather general question that popped up throughout different panels. And I'm really sorry, I cannot do justice to the richness of the debates that have been going on in all panel sessions. But one fundamental question that came to the forefront was the question, is competition law moving from a more economic approach to a more legal approach? If we impose stricter regulatory obligations inspired by competition law, we give in a certain way more certainty to some businesses that some types of behavior are automatically per se, if you want, prohibited, and other types of behavior are not necessarily prohibited. Whereas with open norms such as an abuse, a prohibition on abuse of dominant position, a prohibition on restrictive agreements, there is more room for debate, more room to bring objective justifications, efficiencies-based justifications to the forefront. Now, more legal obligations then that trigger the question, is this going to lead to more legal certainty? And there, of course, the question is, what is the conception of legal certainty we want to maintain and entertain in the context of competition law? Is that sound economic analysis that underlies decisions whether or not an infringement has been made, or is that a clear set of ex-ante rules that determine what is possible and what is not possible? I personally think that legal certainty can contain both types of reasoning. Clear regulatory obligations do not exclude sound economic analysis. It only shows that competition law is more than just economics. Competition law is EU economic constitutional law, if you want, and the rule of law, and that brings me, I try to square the circle, or that brings me back. So the rule of law is also an important element that maybe not explicitly, but at least implicitly figured in our debates on how to structure enforcement, how to think about substantive modifications in the context of the digital economy. I'm going to stop here. Thank you very much for your attention.
Thank you very much, Peter, for this lively presentation and for announcing something I already wanted to remind, namely that the recordings of the working sessions are going to be online next week, approximately. Anna, Orla, Peter, I would like to thank you again for your excellent briefs, and I have now the pleasure to chase you away because we have to make room for the panel. Thank you very much.
Thank you very much, Sasha. And the rapporteurs, thank you so much for giving substance to the main topics of FIDE 2021. You have achieved everlasting fame and a well-deserved present, but so another big applause perhaps for our rapporteurs would be nice. Okay, dear FIDE friends, we move straight on to our next very promising panel on the role of courts in upholding the EU's foundational values in Article 2 of the Treaty on the European Union, not only limited to rule of law aspects. All panel members and our moderator, please, Rick, please come forward and have a seat at the table. Meanwhile, I will try to entertain you with a small anecdote. When I started to walk and talk as a little child in the early 80s of the last century, the last Dutch FIDE Congress took place in The Hague. At that time, the great Professor Schermers invited law students to join and be of help of the organization. And just as several European law students with their blue FIDE 21 jumpers provided invaluable help this edition. Well, one of those students, present in 1984, became very inspired and devoted a long and impressive career to the field of European law. No one else than the great Professor Rick Lawson, who has been of great support to the FIDE Congress 2021 as well. A student in 1984, he's now our moderator for the following Leitmotif panel on the EU's foundational values and the role of courts. And he will further introduce our distinguished panel members. Thank you.
Thank you very much, Herman, for stealing my introduction speech. When Sasha opened the first session, she said that we were at the beginning of the end. So I suppose that we're now at the middle of the end. I hope that this is not inspired by the theme of our panel, but rather by the program. And let me say, first of all, a big thank you for the organizers for including this panel. Of course, I'm also grateful for the panelists for being here and for the audience for showing up on a Saturday morning after a Friday evening. But I'm very happy to be included in the program. As you rightly said, Herman, it's great to be back in The Hague after 1963, after 1984. Last night we were reminded by the Burgomaster, the Mayor of The Hague, that actually the Congress of The Hague also took place here with Sir Winston Churchill in 1948. Our foreign guests might be forgiven to think that in this country we only have one city where you can have meetings, which is The Hague. Actually, it's a small wonder that the EU managed to adopt treaties in some other places, Maastricht and Amsterdam. How the EU managed to get meetings in these cities and escape from the reach of The Hague will remain a miracle forever. But it's true, I was here as a student in 1984. I didn't have the hoodie or the sweaters. I'm jealous of you, but then we didn't have to check QR codes either, so your job is more complicated than it was in our time. Full circle. The topic of this panel, in a way, is also full circle. We're going to talk about the rule of law, not for the first time during this conference. Full circle because already in the opening speeches by our President Wissels and President Leynaerts, and also first Vice President of the European Commission, Frans Timmermans, the rule of law featured very prominently, and they really conveyed a sense of urgency on the topic. And as we have just heard, the rule of law continued to be a recurring theme throughout the working groups. Even Working Group 3 on the other level couldn't escape from the rule of law. We tend to think these days, and that is for a reason, of course, that the founding values of the Union as they are mentioned in Article 2 of the treaty, are all about the rule of law, but that of course is not true. The rule of law is just one of the founding values, and we have an excellent panel to elucidate on the other values and the other elements which are in Article 2 as well. So, without further ado, I want to give the floor to the 5 members of our panel. I will introduce them one by one when they take the floor. We had quite serious negotiations in the running up to today. I think that the current discussions with the UK about Brexit are nothing compared to the fierce discussions we had about how to spend the coming minutes and hours talking about this theme. Initially, we agreed that each of the speakers would have 5 to 7 minutes for a short introductory statement, but then they all started to lobby to have more. So now we have said 10 minutes for each speaker individually, which should take in total about 45 minutes. And then we would have ample opportunity for discussion between the members of the panel and with the audience, and we would encourage the members in the audience also to raise questions. Now, with these formidable speakers, of course, this is not going to work. They will never, ever be limited to 10 minutes. But the organizers of the conference had this wonderful idea not to provide us with chairs. They have to stand, and we all know that after a while one gets tired. So if we manage to keep time, it's not because of me, but it's because of the lack of chairs. Having said that, I'm delighted to give the floor to the first speaker who is standing next to me, Judge Rossi, who needs no introduction. None of the speakers in this panel actually needs introduction. She has been a member of the Court of Justice since 2018. Before that, she had, despite her apparent youth, a long and distinguished academic career, teaching European law at the Università di Bologna, our alma mater, and she will reflect on our topic. Judge Rossi, just to kick off, we have the values in Article 2 of the treaty, but they're not alone. And we also have rights, we have principles. In addition to Article 2, there's Article 4, there's Article 6, there's Article 19, there's many articles. What to your mind is the place of Article 2 and the values contained in Article 2 in the larger scheme of things?
Thank you very much. I'm not going to speak as a judge, but just in an academic perspective, so what I'm going to say doesn't engage the court, of course. It is the right time to try to make a general assessment of these provisions introduced by the partly introduced by the Treaty of Lisbon, and you mentioned several articles of the treaty, but what is very interesting, according to me, is to put Article 2 in context. Why? Because Article 2 embodies now the essential values, core values of the membership, the values that are strictly connected to the quality of member state. So Article 2 is not a decoration, is a provision, is why one of the first provision of the treaty, and it must be given a sense. How to give a sense to Article 2? We have to assess Article 2 in the framework of the other provisions of the treaty that you mentioned. The first provision that is important is the connection between Article 49 and Article 2. The court has already expanded on this point in a recent judgment. In the moment you accede to the EU, you have to comply with the respect of the founding values of the EU and as embodied by Article 2. So these are not only fundamental values, they are founding values. And Article 49 imposes a condition. So this is a set of values that cannot be given up if you want to continue to be a member state. This is something that is relatively new because, you know, it was already the Treaty of Amsterdam, speaking not of values at the time, but of principle, but the connection between accession to the EU and fundamental principles, such as rule of law and others, was already established by the Treaty of Amsterdam, and then by Article 6, in the same time, Article 6 of the Treaty of Nice. So my point is that all this was clear even before the very large accession of 2004. The states that acceded in 2004 already should have been prepared to this set of values that had already been established by the Treaty of Amsterdam. Now the richness and the complexity of this set of values has been increased by the Treaty of Lisbon. There are now, it is now clear that Article 2 has relations with Article 19. We have many judgments of the Court of Justice. Article 19, the juges portugais, the Portuguese judges, say Article 19 is an expression of Article 2. So this is why Article 19 is so important, because it's part of the founding values enshrined in Article 2. And if you read Opinion 213, connecting mutual trust among member states and respect of the values of Article 2, or Opinion 117, saying that the values are a part of the EU constitutional framework, you can understand how Article 2 is the core of a European constitutional identity. And this is brings me to compare Article 2 and Article 4.2, that is a national constitutional identity and, let's say, European constitutional identity, or at least the respect of the values of Article 2. This is a very interesting point. The court has not yet fully expanded on that, but I presume that sooner or later the question arises. And so Article 4.2, what is? I think that, again, if you read the case law of the Court of Justice, you see that Article 4.2 has so far been treated used for cases that were not two categories of cases. One is very similar to mandatory requirements, traditional mandatory requirements. For instance, if you take Torresi for the lawyers, or Sein-Wittgenstein, Bogendorf, Wonkredorf for the titles of nobility, the case Commission versus Luxembourg for nationality of a notary, and pension, O'Brien, Lass, Digibet, we have a lot of cases, a lot of judgments. You see that those elements of national constitutional identity, which were invoked in those cases, were not much more than traditional mandatory requirements. And at the end of the day, the court treated them as mandatory requirements, following the traditional test of proportionality. Now, the difference, theoretically, there can be a difference between mandatory requirements and elements of national constitutional identity. Why? Because, as you know, the theory of the test of proportionality in mandatory requirements starts from the idea that the requirement invoked by the member states must be of the general interest of the European Union. This cannot be necessarily said for element of national constitutional identity. There must not be necessarily an element of an objective of general interest of the European Union as such. We have also some other cases. The most recent is BK about military activities, but also some cases about the territorial competencies within the member states. Here emerges the true nature of Article 4.2, that is, there are some issues that cannot be just qualified as mandatory requirements, and they are pertaining to the structure. They are structural features of the constitution of the member states. For defense, Article 4.2 introduces a specific assessment, a specific evaluation of competence of the member states, exclusive competence, so it is particularly strengthened. But what is at the end, in my opinion, the plus of Article 4.2 is just to try to embody in the EU legal order the traditional theory of counter limits that were developed by the national constitutional court. In this way, the counter limits become also an element of the EU legal order, not only of the national, no more only of the national legal orders. So this is Article 4.2. But can we say that the issues stemming from Article 4.2, the national constitutional data, can prevail over the values of Article 2? My answer is no. It seems to me very clear that this is not possible, because Article 2 values are the values of the membership. So in case there is a real contrast between the national constitution and the core values of the membership, the state has only two alternatives. One is to amend the constitution, and the other is to exit. I mean, the case law of the Court of Justice often stresses that the accession to the EU is a voluntary act, and also I must add that Article 49 stresses that all the accession is made according to the national constitutional requirements. So when a state accedes to the Union, the Parliament is involved, all the constitutional bodies are involved. They accept a treaty, they accept all the engagements stemming from the treaty. And I must say again that Article 2 values are not new. If you want to go back to the history, they were introduced not for Poland, not for states that are members. They were introduced in Amsterdam thinking to the accession of Turkey. That was the moment where these values were introduced. That was the moment where the procedure of, which is today Article 7, it was at the time Article F1, were introduced. Because there was the fear of this new potential member state. So it was not, I mean, a sort of méfiance towards the member state that acceded in 2004, not at all. It was a thought for Turkey. That is the history that all professors know about this, the introduction of this measure. A last remark is about how to protect the values of Article 2. There is only one instrument, or there are more? I think that there are more than one, not only Article 7. And it would not be logic to think that for the most important value of the EU legal order, only one extraordinary and not a very effective remedy is provided, excluding all the other remedies. That would be, I'm sorry, not very logic. So all the usual remedies provided for by the treaty must be applied. I remind that Article 269 only limit the jurisdiction of the Court of Justice to the procedure of Article 7, not to the procedure, not regarding Article 2. TU. So there is no limit to the jurisdiction of the court in assessing violation of Article 2. It is true that Article 2, by its nature, is usually combined with other provisions that can be Article 19, for instance, that could be in the future provisions of the Charter within the scope of the Charter itself, in combination with the Next Generation Fund, Next Generation EU regulation. So we have different tools in order to make Article 2 respected, and we cannot accept the idea that Article 2 can only be protected by means of Article 7. I think that I have more or less said everything, and I'm completely willing to answer to any question. Thank you very much.
Thank you very much, Judge Rossi. A very, very short summary of your introduction. Too blunt, obviously, but being Dutch, I would be forgiven for being blunt, would be up or out. This is what I noted down. Many questions come up, but without further ado, we move on to our next speaker, which will be Judge Kees Sterk. In the old days, we would have the philosopher kings. Nowadays, we have the judges professors, and he's one of them. Judge Kees Sterk is a senior judge at the Regional Court of Maastricht. He is also professor at the University of Maastricht. Before, he was a member of the Dutch Council for Judiciary, and I suppose that in this audience he's mostly known for his great work with lots of energy and insistence as president, chair of the European Network of Councils for Judiciary. Judge Sterk, when you started as a judge and as a member of the Council for Judiciary, and you joined the network, did you expect that you would rely on EU law so much as you did during your term of office?
No, not at all. Not at all, to be honest. Thank you, Rick. Ladies and gentlemen, I want to say a few words about the rule of law. Not all aspects of the rule of law, just about the independence of the judiciary. And I have 5 points. They concern what judges can do in upholding the rule of law, not in their judgments, but more outside their judgments. And my first point is values are law. In 2019, András Varga published a book under the title Rule of Law, From Ideal to Idol. András Varga was at the time a member of the Constitutional Court in Budapest and is now the president of the Supreme Court in Budapest. And what he's saying is that rule of law, independence of judiciary, are just words. They are a magic wand in the hands of judges, in the hands, in his view, of the West to impose on the East the values of the West. They are just political concepts. And this line of thinking you find back in the recent decision of the Polish Constitutional Court. And I quote from that decision, of course, from the English translation: the values of Article 2 are merely of axiological significance, and they are not legal principles. That's in paragraph 19. And the Polish Prime Minister said this week in the Dutch newspapers, rule of law is not a problem, it's just an imaginary problem. Well, as I was a president of the network of councils for the judiciary, we had to deal with the situation in Poland. At a certain point in 2018, we found that the council was not independent anymore, and that is a requirement because the network adheres to the value of the rule of law. And we imposed, and we started a dialogue with the KRS to see what's going on, what they were thinking, and whether they would improve. And unfortunately, I must say that the dialogue was very difficult with them because there was no common ground. There was no common ground on the issue that the rule of law is law. Values are law. And so that was, for the network, they had to take the sad decision to expulse the Polish Council for the Judiciary 10 days ago, not to punish them, but to make clear that it is of importance to uphold the integrity of the network, to draw clear lines of what rule of law and independent judiciaries are about, and to make these red lines public. That is my first point. Then the second thing judges can do outside their judgments is help in articulate common standards in Europe. And this has been done for quite a lot of time. There is the work of the CCJE. They just updated an opinion on judicial self-governance. There's, of course, the work of the Venice Commission, the European Judges Association, MEDEL, European Administrative Judges, the network I was representing. And articulation must lead to identification of problems and working on solutions of these problems. And we do that in a dialogue, but on the basis of the common basis that rule of law is law. And we have to find out what this exactly means in a changing context. And the dialogue is with other judges, with courts, with the universities, and we started to have dialogues with parliaments. Not in every member state. This is self-evident because of their idea of separation of powers, and in some cases that they fear that the dialogue would not be on equal basis. That is my second point. Then my third point. If I look very briefly with a helicopter view at the situation in Europe as to independence of the judiciary, there are two main problems. The first is the appointment and promotion of judges. The common rule is very simple. Appointments and promotions must be done on merit and experience, not on the basis of loyalty to politicians or to whatever. Only loyalty to the law, one could say. The only loyalty is to the law. And you see three kinds of problems in this respect. First, the appointments are seized by politicians. That's the case in Poland. But also in some countries where the standards are in place, one would say, judges feel that there are problems. There are a number of years, there are surveys saying that the judges in Spain, France, Portugal, Bosnia, and there are some more, feel that appointments and especially promotions are not in accordance with the standards. And sometimes standards are in place, but the danger does not come from outside the judiciary, from the executive, but from within. And I'm sorry to say, but perhaps Italy is an example of this, where the judges' associations, the Correnti, they divide the promotion places among each other. In the Council for the Judiciary, there was a huge scandal about this some 2 years ago. And the second problem is, of course, disciplinary proceedings. And the rule here is also very basic and elementary. No disciplinary or disciplinary proceedings or dismissals on the basis of the content of a judgment. There are other ways to deal with that. And if I look, I got this text just recently. The Minister of Justice in Poland just introduced a new law to the Polish parliament, saying that in case a judge from the Supreme Court would question the status of another judge on the basis of EU law, that would be deemed as a dismissal. So it goes on and it goes on. It's just another technique and so forth. That is my third point. My fourth point is what can be the strategies of courts and judges. Of course, the first, perhaps the most important strategy is use all the instruments of EU law. I will not mention them. You know what I mean, what I talk about. But the problem is, of course, and the president of the court already said, the decisions of the court must be executed, of course. There must be a political will. And not only a political will to execute judgments, but a political will to uphold the other elements of the rule of law who are not yet articulated in judgments. And that is I think, a problem. And Karin Greiter said in this Congress, Europe is about muddling through, and it keeps us going, and it is more or less okay. And her book is called It Does Not Get Any Better. But I say, as to the specific point of the independence of the judiciary, of which the common constitutional traditions are rather clear and the rules are rather basic, and these basic rules are very essential for the EU system, there is no room for political compromises on this. That is the first strategy. And then I come to a second strategy. I was in Gdańsk 2 months ago at the anniversary of the Justitia Judges Association, and they said, what if you have a majority of a parliament that does not respect the rule of law? What if your constitutional court is captured? What if the judgments of the ECJ are not executed? And what if political compromises are made? What are we going to do? And the judges there said, and former President Gersdorf was one of them, he said, we made the mistake to put all our cards on rules. Rules, the rules of our constitution, the rules of Europe. We should have gone more to the public and gained the trust of the public. And we should have worked on that. And now the judges in Poland are visiting schools, festivals, marketplaces, also in the East, whereas the core voters of the present government. And I think that could be a lesson for more judiciaries in Europe as well. My last point.
In the interest of time, could I ask you to wind up?
Yes, I will just say the last sentence.
Okay.
I will skip a little bit. I would recall a judgment of the Strasbourg Court saying that judges should not enter into the political debate, and I fully agree with that. But there's one exception, and the exception is when the rule of law and the independence of the judiciary is at stake. Then judges are not only allowed to enter into the public debate, but it is their duty to defend it. Thank you very much.
Kees, thank you very much for a powerful speech. I hated to interrupt you, but if we want to protect the rule of law, we should also comply with it. So without further ado, I turn to our third speaker, Judge Siofra O'Leary from the European Court of Human Rights. I've always believed that European law is more than the law of the European Union. It, of course, also includes the law of the Council of Europe and the European Court of Human Rights, to which Judge O'Leary was elected in 2015. She is currently president of Section 5. She's no stranger to Luxembourg, if this can reassure you, because she was référendaire, chef de cabinet, worked in the research division, and she was a member of the board of editors and the advisory board of the Common Market Law Review. How much better can you get? Judge O'Leary, from your perspective as a Strasbourg judge, how do you reflect on the foundational values of Article 2 of the treaty?
Thank you very much, Rick, for your introduction, and thank you for the invitation to be here. Rick explained that a measure of austerity imposed on us is that we have to speak on our feet. What he didn't explain is that it's actually very dark up here, and you may have noticed that these panel members are not as young as the panel members who preceded us. It is likely, although I'll try my best, that I will continue in the timing in discipline which has been demonstrated so far this morning. It's fine, thank you. Dutch chivalry.
Case is always ready to enlighten us.
Now, light in the darkness.
Although the courts in Luxembourg and Strasbourg form part of legal systems which we know are significantly different, the core values listed in Article 2 following the Treaty of Lisbon mirror, of course, those which are reflected in the Statute of the Council of Europe, dating 1949, and indeed the preamble of the now 71-year-old Convention. And the Strasbourg Court has, of course, repeatedly stated that values or principles, approach them as you wish, like the rule of law, human dignity, or solidarity, are inherent in or underpin the entire Convention. Think of cases like Golder from 1975, Christine Goodwin, 2002, or Wawrzycka against the Czech Republic on solidarity just last year. This symmetry of values between the two European systems manifests itself in quite general, but also in very concrete ways. And I should, of course, stress, and I should have said this in the outset, greetings from Strasbourg, but of course, like Judge Rossi today, I don't speak for Strasbourg. And moreover, I will follow the jurisprudence of my own court and not engage this morning in a political debate, touching on any pending issue or any judgment handed down which is related to a pending issue. However, Judge Rossi has explained how her court has developed its impressive judicial response in relation to rule of law and judicial independence issues, which I know has been the subject of discussion from the beginning of the FIDE conference. However, while this territory was novel in terms of EU law, this was not virgin European territory. The Luxembourg court had, of course, at its disposal abundant Article 6 case law, recapitulated, for example, in the recent Adstradsen against Iceland judgment. And perhaps more importantly in recent years, preliminary rulings in given cases have been followed by concrete judicial findings in Strasbourg on individual applications which have been brought by judges, prosecutors, members of national judicial councils, or litigants appearing before courts whose judicial independence is challenged. And these cases come not just from non-EU member states, but of course also from EU member states. Now this brings me to my second point, the question of sources and how at European level we might frame, perhaps a little bit more effectively, our references to common values. The important ongoing dialogue between the two European courts is quite obviously not exclusive to them. In fact, it's a dialogue entirely driven by national courts. Think of Aranhosi, the Portuguese case, LM, Open Bar Ministeri, Dorobantu, Jawu, and now Orlovsky from the Irish Supreme Court. In all of these cases, it's national judges who have, more often than not with reference implicitly to Article 2, but very explicitly in relation to their own constitutional values, and indeed the European Convention, referred questions seeking guidance from the Luxembourg Court. And even in cases which haven't been referred, I'm thinking, for example, of the 2015 seminal order of the German Constitutional Court on convictions in absentia and the European arrest warrant, what was central were core constitutional values like human dignity. Now, national courts have therefore entirely led the way, and I salute those who are here present, in the judicial operationalization of the rule of law and other values via the Court of Justice, but also in their own national constitutional courts, where the Convention features very significantly. And how could the centrality of national courts, national constitutions or the Convention be any different. In parts of its case law on Article 2, the Court of Justice frames its references very clearly in terms of common and shared values. Look at cases like Republica or Simpson. And as a European human rights judge who started off, of course, as an EU lawyer, as Rick explained, I do perhaps naturally return to cases like Internationale Handelsgesellschaft and Rutilli from the 1970s, because we can't forget that that paradigm shift which occurred in the 70s was inspired by member states' concern at that time that EEC law posed a threat to the foundational values which underpinned their system. Why do I go back in time? Because it seems crucial, given the evolution of EU law and the treaties, when engaging in a dialogue in a European community of judges, not to lose sight of the sources of and inspiration for the values in Article 2. And in terms of how we frame references to Article 2 values, and of course I'm coming at this from a non-EU external perspective, a question worth reflecting on today is whether, when one adds to the mix the EU as a distinct and autonomous legal order, the autonomy of the Court of Justice, EU principles of effectiveness and unity, what risks emerging, and I stress to the ears and eyes of certain states, is the false impression of a top-down imposition of something which feels external to, rather than born of, their own national and constitutional heritage. That the impression is false doesn't mean we don't have to engage with the false impression. Many national judges might react to the proposition, which I've seen Judge Rossi refer to in her excellent writings, that common constitutional traditions are an autonomous concept of EU law. For them, there may be a contradiction in those terms. So how can we more effectively frame the message if the message is being misunderstood? And here I pick up on some of the points made so eloquently by Judge Rossi. It could be argued, in the case law as it stands, that Article 2 is seen too rarely in the company of Article 6, paragraph 3, or the preamble of the Charter, where the origins of the common values are so very clearly identified, or in the company of Article 6, paragraph 2, where the legal basis for the future relationship with the European Convention still, of course, resides, or indeed with Article 4, paragraph 2. And I agree entirely with Judge Rossi that national identity cannot be bandied around as a means to decline or derogate from foundational values. But that doesn't, of course, render a provision like Article 4.2 obsolete. The Lisbon Treaty added both it and Article 2 to the toolbox for a reason. And as the President of the Court of Justice has stated, neither European unity nor national diversity can or should be absolute. And it's also worth remembering that as the EU Charter was being bedded in over the last decade, considerable care was taken to avoid or limit its potentially centrifugal force. Despite the essential, indeed central role now played by Article 2, and a role which I hope I have indicated is both supported and rendered more dynamic by Strasbourg and national judicial dialogue with the Luxembourg Court, it is worth asking whether limits to the potentially centrifugal force of Article 2 itself are not to be found in some of the neighbouring articles of the Treaty on European Union just listed, or in the softer, more inclusive terms of the EU Charter itself. The discourse of values is very powerful, but beyond Article 2 and Article 19, paragraph 1, which work so effectively in tandem, one does have to ask, does the discourse of values not also harbour some risks? A broader treaty approach to Article 2 and a more consistent location of the origins of values at national and not just European level would not, in my view, undermine autonomy or authority. It would likely enhance both. The Court of Justice would be engaging in the dialogical process with national courts, which I understand Judge Lennertz emphasised the other day, is so essential to both of those bodies. Now let me turn a very critical eye to my own court for a few minutes. What's the role of the Strasbourg Court in relation to systemic or value problems, or to what some have called, I think Professor Kosar might have baptised this term, abusive constitutionalism? The Convention's focus is on individuals. We provide individual relief in individual cases while also setting general human rights standards. And doubts about the Strasbourg Court's capacity to function as a rule of law court are quite legitimate for this reason. Professor Kosar, in fact, provided an excellent critique of the Strasbourg Court's early engagement with rule of law and judicial independence issues in Baka. However, more recent judgments like Bilcinen against Turkey, Astradsen against Iceland, Kovesi against Romania, to name but a few, surely highlight the reach and robustness of the Convention in this field. Firstly, take any EU member state or state aspiring to EU membership. Look at the cases pending before the Strasbourg Court and look at the judgments handed down against that state in the preceding few years, and what you have is a judicial X-ray of its Article 2 state of health. Italy, Poland, Romania and Hungary all feature on the Court's top 10 respondent states in terms of pending applications, and for each one, if you look at the X-ray, you can identify the systemic deficiencies. Secondly, the Strasbourg Court has developed a pilot judgment procedure as a means to identify the structural problems underlying repetitive cases and impose an obligation on states to address this. And in the EU context, we now see some scholars calling for, in essence, a pilot judgment procedure. Thirdly, while execution of the Court's judgments is clearly not optimal, judgments finding violations of Convention provisions are powerful tools which position human rights, the rule of law, and democracy in domestic public discourse. Fourthly, the legal debate about Article 2 values at EU level has focused understandably on rule of law backsliding and judicial independence. But the Commission's rule of law reports casts the net much wider. They look at anti-corruption frameworks, media pluralism and freedom, and other institutional checks and balances. And is it not in Strasbourg case law and in the Council of Europe bodies that Judge Sturck referred to that many of the hard and soft law mechanisms needed to redress these problems can principally be found? I come to my concluding point. This panel met in October for what I now understand was a tough round of negotiations, but this topic was chosen over 2 years ago. And the wish then, and I think it's important to maintain that wish now, is that our discussion of this very important topic is not focused on 1 or 2 member states or on what is currently the most obvious component of Article 2, the rule of law and judicial independence. What of human dignity, democracy, equality, solidarity? Go back to the travaux préparatoires of the Constitutional Convention. I did, and I was struck by how many delegates sought to amend the text to ensure that Article 2 emphasised equality, solidarity, and equal and social justice. The crises which have engulfed Europe since that Constitutional Convention, financial, migratory, existential in the case of Brexit, perhaps more existential for some member states than for others, highlight the importance of these values to all Europe's citizens whose rights, interests and aspirations Article 2 also serves. I thank you very much for your time and apologise to the translators if an Irish woman asked to speak against a stopwatch hasn't led to steam coming out of your ears. Thank you.
Thank you very much, Judge O'Leary, for a presentation that was thought-provoking and everything but centrifugal. Very interesting ideas and no doubt food for discussion. I now go to who's probably the true hero of the panel, Judge Knets, who at a very late stage accepted the invitation to join this panel. Actually, only a week ago, my colleague and friend Jorrit Reitma somehow miraculously managed to convince him to abandon, I think it was Glasgow, where you were supposed to be right now. We had suddenly a vacancy in the panel, and Judge Knets was willing to step in, which is really admirable. As you have seen, he is a president of the Constitutional Court of Slovenia, has been an academic as well, professor at the University of Maribor, another philosopher king who joins us now, a judge, professor. You have the floor. Thank you very much for being with us.
Thank you. Thank you for this lovely introduction. Indeed, and I didn't prepare as well as I used to prepare for speeches, and I would like to actually to share with you my thoughts being very practical of what is going on at the Constitutional Court and how I see actually the principle of primacy and other principles of European Union law. And I think I was naive, not being here, of course not. I was naive years ago because I thought that principles like primacy and other fundamental principles of EU law are closed topics, that everything was set. These are fundaments for European Union law, not only for law, for European Union itself. We can only salute ECJ to shaped 50 and more years ago these principles, and why are we still talking so intensively about this principle? We should be applied basically every day in every case. Here is how I think. At national courts, we have to apply, the Constitutional Court at least, in any case, 3 legal systems: EU legal system, international legal systems, above all the European Convention of Human Rights, and national rules, above all Constitution. So somehow we have to apply consistent interpretation to all of them. And I know it used to be much easier. In times of single market, of European community, things was very simpler. Nowadays there is no simple case. What happened? It happened actually that we moved from the community to union. And I'm saying this positively. It's not going to be anything negatively in my speech, and I'm also trying to avoid political elements in all these issues. You know, as a definition, a community is a group of people who are joined by the same values, by the same goals, visions. And this we had actually in times of single market and common market actually only as economic prosperity. And it was easier, this synergy in terms of economic prosperity is much easier to find than when we moved actually to something which is much broader, to union. And of course, also questions that are given to judges to answer them are much more comprehensive, are much more particular. They are coming from areas where they used to originate from internal national areas, etc. So being confronted with all these issues, sometimes I really do think that we are touching upon a core dilemmas of not only EU law, also international law and national law. And sometimes we are faced with a question where I would like to start a preliminary ruling reference to both courts, Luxembourg and the Strasbourg Court. So far, there were several such cases, and we did not refer any question. There is one element also, nobody is talking about this element, is the element of time. If we start after there is a case in our court for 2 years, for instance, and if we start a procedure at the Luxembourg court, and then we are getting back the answer in a form of judgment after a year or so, and then we're still going to need some time, it might be that we are going in the breach of Article 6 of the Convention, or 13, because of the length of the procedure. Now, this is not a valid argument, of course not a valid argument, but there is behind our thoughts nevertheless. But the fact is, and this is my emphasis for today's speech, is that when we touch upon these core dilemmas, and especially when other courts are touching, regular courts are touching upon these core dilemmas, and they're answered by the Luxembourg court, ECJ, coming back in a form of judgment, and they are resolved most of the time, this is just perfectly. But when the case goes on, coming to the Constitutional Court, it's already decided. It is decided by the ECJ, and we don't want to talk anymore. So somehow we are left aside. And even the regular court did not say anything about the, let's say, core dilemma, that is also a national core dilemma, which could have been taken into account by the ECJ. So somehow we are missed out, the apex courts in national legal systems. So this is my dilemma. And I think that both national courts, having in mind first and second instance courts, when asking a preliminary ruling reference, they should also have this sensibility that the question is touching upon a core constitutional dilemma in the national state. And also, perhaps the ECJ can find out that way that this is something that might cause problems later on in member states. So this sensibility in this dialogue between courts should be given some more emphasis. I think that from 50s on, we have this provision of preliminary ruling reference, which is a fundament, but it was totally okay, in my opinion, for single market, etc. Nowadays, it's still okay. It's still okay. I'm not saying to change anything. It used to be my idea, actually, that somehow the Constitutional Court should be also involved in preliminary ruling reference, but I've learned in a Riga conference 2 months ago, actually, that even most of the constitutional courts do not support this idea, so I admittedly saying now, but somehow this sensibility of issues that are different than they used to be should be included in this dialogue, and the dialogue should be even more intensive. You know, democracy is slow, is a complicated process, and we should be a little bit more flexible, more soft, not so stiff when these core dilemmas, which are now present in last decades, are answered. I would like to stop here. Thank you.
Thank you very much, Judge Knez. When listening to you, I realized that you were not provided with a glass of water, presumably because your arrival was so unexpected, but you certainly deserve a drink. Thank you very much for your introduction, and again, a lot of appreciation for your willingness to join the stage today. Without further ado, I would normally turn now to our last speaker, Professor Kozar from the University of Masaryk in Brno, Czech Republic, but I think that your academic work has already been summarized by Judge O'Leary, so I assume that we can skip your intervention, or would you?
You can surely skip that intervention. So thank you very much, Rick. Thank you very much for having me here. It seems like I'm the only non-judge on this panel, and I probably can say things that judges cannot. So it seems like the Czech speakers at this FIDE Congress are destined to be enfants terribles. So, are you getting to the question? Or?
Please, no, please.
Okay, so I was supposed to talk about limits of courts to upholding EU's foundational values. So, first of all, it's clear that it was already said by Anna that there are some sort of external issues. So we place a lot of burden on courts because, I mean, separation of powers in the end is also a joint enterprise of governance. So without the legislature and the executive, it's difficult to achieve those values. But I would also say that we need to look, and that's also limiting the courts and the informal institutions and constitutional conventions.
and the domestic level that often limit or shift the former solutions. I think we also need to look probably at the dark role of the church in some countries when we speak about the values, because in some countries, I'm not speaking only about Poland, but also, for instance, the United States, the church, if it gets what it wants, let's say regarding the abortion rights, it is willing to sacrifice the rule of law principles. And it was greatly summarized by Judge Sterk. We also need, at least in the long term, the support of the people, because without them, it's extremely tricky. So it's necessary to increase the public trust, to mobilize the people to defend the Article 2 values. But first of all, we need to educate people about those values, and probably very early. And it's still surprising how little about this is said, in high school curricula, even during the legal, education when black letter law is taught. Look at the judicial exams in many countries. I mean, well, these values are somewhere in the background. And then, of course, it gets tricky. So we need to think about these foundations, as well. And I think we also probably might reconsider some more innovative solutions, such as online courts. I know it's a controversial idea, but we need to understand that many people do not care about judicial independence and rule of law because they've never been at the courts and never even contemplated of using courts as the means to basically resolve their dispute. And we need to find a way how to broaden the access to justice also in those ways, even though online courts raise all sorts of other potential issues. It seems to me also that one way how to give judges some allies and sort of reduce the pressure is to focus on the so-called fourth branch institutions. In the words of Mark Tashnet and Tarun Khaitan and others, that is this guarantor institutions, can be election commissions, it can be ombudspersons, think of Adam Bodnar in Poland, even judicial councils, and I get to that later, can be reframed as fourth branch institutions to increase their legitimacy. But I also think that and that's perhaps where my background comes in, because I'm used to travel between bubbles. I mean, EU law bubble is only one of my many bubbles. I also, travel to, comparative constitutional law bubble, think of ICON, travel to, international law bubble, think of European Society of International Law. And it seems to me that, these bubbles are quite separate. And there are very few persons who travel at all of those places that try to find a common language. Among the three, there might be even more bubbles, of course. And it's unfortunate, because then it seems to me that at least in certain jurisdictions there might be a huge division between EU law scholars and domestic constitutional law scholars. And of course, when we are speaking about the rule of law, separation of powers and judicial independence, we need the two to work in tandem. So it also requires perhaps the Court of Justice to try to speak a language that is, understandable to domestic constitutional scholars, and sometimes perhaps not, if I put it bluntly, reinventing the wheel. So, for instance, when we are talking about, the systemic defects of the rule of law, there have been already some mechanisms out there how to assess these systemic defects. When I look at Rick, who's coming also from a human rights background, there's this famous 1503 resolution that basically says when the systemic effects of systemic violation of fundamental rights takes place. And we can use those, criteria, or at least adjust them to the EU law context, rather than bringing something completely new. So that's my first set of comments, and I think in the end, it's important for judges to build alliances for, not only with the public but also with political opposition and supranational institutions, media. In civil law countries, the bar. There is also, in common law countries, the bar and the bench, they, sort of work together. But in civil law judiciaries, we all know that judges are somehow, skeptical of members of other legal professions, which is also tricky and somehow undermines the legal profession as such. So from this point of view, also when I look at the case law on judicial independence of the Court of Justice, sometimes I have this feeling, and here I would echo Kester, that there is sort of this nirvana's fallacy, as termed by Adrian Formella, that we compare the worst possible picture of the legislature and the executive against the idealized vision of courts, because judges in some countries, they are corrupt. In some countries there is nepotism within the judiciary. So even if there is no corruption, all of a sudden somehow family members win the competitions for new positions within the judiciary, no matter whether it's the selection is by the executive or by the Judicial Appointments Commission or whatever else. Of course, judges can be biased. They can have ties to political parties, like in Italy, but also elsewhere. The Spanish Judicial Council is also very much politicized. There are connections to political parties in the French judiciary as well. Of course, the problem of what I would refer to judicial hubris, when you look at and I'm sorry to all the Polish members in the room, when you look at the building of Supreme Court of Poland, well, I'm not sure whether you can build such a building, in the egalitarian post-communist society with these columns, entrance like in the Game of Thrones, glass elevators, a waterfall, and the statues, supporting the building. That can be easily misused and abused by those who want to attack the court. So we must be careful about that. So in that sense, I would say that some of the claims, like that involvement of a body like a Judicial Council or Judicial Appointments Committee is in principle likely to make the appointment process more objective, like in the AK or judgment, or Angelika Šimaityne versus Lithuania judgment, might get tricky. The same applies to judicial review of judicial appointments. Because I think, as did not mention the recent, or have you mentioned the recent opinion of the Consultative Council of European Judges that was approved yesterday? Yes. So you can see that there is sort of, response to that, because there is a growing discontent in certain countries in Central and Eastern Europe with the Council of Europe and EU standards on judicial governance, because they simply do not work. And that's very tricky, because then you have competing claims of authority, and basically the better argument wins. And for instance, there are new antank principles of judicial governance in transitional societies that go very much away from the Council of Europe principles. And losing the civil society can be very detrimental for courts. So in this regard, I would also probably a little bit caution against the non-regression principle or standstill clause in judicial independence or the rule of law, because the standards are still evolving and going back and forth, and it can get tricky. And of course, the European Court of Human Rights, for instance, some of the potential problematic parts of Baca and Emery judgments were, remedied in the Denisov Grand Chamber judgment and so forth, but it's, not explicitly overruling, but certainly shifting the case law somewhere. And finally, just a short note on double standards. I think that quite often the perception in Central and Eastern Europe is not that the double standard is West versus East. We know that it is Lithuanian Prosecutor General versus, the prosecutor's office in Lübeck. That's a fair argument, but the perception is that the double standard is the pro-EU government, let's say, more EU skeptical government, because many problems that that Poland is facing right now regarding judicial governance in Hungary already existed in Slovakia in the late 2000s, and no one really cared. Of course, I mean, it's not a problem of the Court of Justice, or because, I mean, it did not receive any preliminary reference, the infringement procedure was initiated, but the problem is that, I mean, many people view the EU governance as such, and do feel that these double standards might exist, so it's important to dispel this claim. And in the end, I mean, as I said, we are living in the world of competing claims of authority, and the better arguments and the more persuasive claims will win in the end. Thank you very much for your attention.
Thank you very much, David. I'm sure that after all, the audience is really happy that you did take the floor and shared some new ideas with us. I just spoke to the powers that be in this conference, and I was told that we have until, what was it, noon? 1 o'clock, 2 o'clock? No, but we have a slight extension, and we're permitted to go on until 11:30, which should allow for discussions amongst the members of the panel. I know that the strategy not to provide the speakers with chairs didn't really result in very short speeches, but they're going from one leg to the other. So no doubt, and please feel free, there are chairs around, so if you feel very tired, then you can sit. But I'm first looking at these courageous individuals who, unlike you, have been standing now for an hour. Do you have any reflections on the speeches of the others? Judge Rossi, please.
It is about the provocative question made by Siofra O'Leary, whether the common constitutional tradition are an EU concept instead of a national concept. You say that some judges think so. I'm afraid that the answer is even more provocative than the question, because actually, the common constitutional tradition were a concept elaborated by the Court of Justice with its own method, which in full autonomy is an autonomous concept of EU law. It is not assessed by a comparison of all the legal orders of the member states. It's not an exercise of comparative law, is a new law. And I think that in the phrase common constitutional tradition, we have to stress the word common, because at the end of the day, it is up to the court to accept a constitutional tradition as really common and capable to limit the scope of EU law. So this is maybe also a difference between the common constitutional traditions and Article 4.2 national identity clause, where there is no element of comparative perspective. And I think that when we have many judgments about common constitutional tradition mentioned in them, the idea is that there is a flexibility in the EU system. But this flexibility reserved so far to common constitutional tradition is quite weak. For instance, not only Article 6 TU treats the common constitutional tradition as general principle of EU law. But if you compare the Charter of Fundamental Rights, the different paragraphs of Article 52, paragraph 3 and paragraph 4, you see that the treatment reserved to the European Convention is much better than that reserved to common constitutional tradition, because paragraph 3 said that insofar as this charter contains rights which correspond to rights guaranteed by ECCR, the meaning and the scope of those rights shall be the same as those laid down by the said convention. while insofar as the Charter recognizes fundamental rights as the result from the constitutional tradition common to the member states, this is paragraph 4, those rights shall be interpreted in harmony with those traditions. So what will be interesting is also from a theoretical point of view is to compare this different concept of common constitutional tradition and the identity, national identity or national constitutional identity clause. There I see that for Article 4.2, a national constitutional court can say, this is the core of my national values. There is 2 steps in this reasoning. It belongs to the National Constitutional Court to assess what is really essential for them. And then it belongs to the Court of Justice to assess whether this issue can be accepted as a derogation. So it is, I mean, a two-way. And this is, in my opinion, the reason why it's so important that national constitutional courts really dialogues with the Court of Justice, with preliminary ruling. In Mass MB, we had a positive result of this dialogue, with the Constitutional Court saying, this is my core value, and the Court of Justice saying, yes, we can accept it as a derogation. So it's a mutual, the result is a mutual. While common constitutional tradition were very much loved by the comparatists, the comparative lawyers, but I don't think that now with the Article 4.2 there is much room. Thank you.
Thank you very much. I'm tempted to ask whether national identities can evolve and whether a reference to constitutional traditions is only referring to opinions that have been shaped in the past, or that we can have newly emerging traditions, and even whether new governments can discover new traditions or elements of their identity. But I'm not going to ask this question because Judge Knez asked for the floor. You have the floor, please.
Thank you. If I may, because I'm a bit confused for more than a decade now for these concepts of what is value, what is principle, what is a common tradition, etc. And I think that at the end of the day, when we have to adjudicate the case, it's not so important what is the name, what is the title, how do we call something. You know, you cannot get wet from the word water. The word itself means nothing, so the substance is what is at stake. And this is why I'm always referring to core dilemmas. I'm not referring to ultra vires, I'm not referring to values, principle, etc. All of them might cause disagreements. And when it comes to disagreements, it's okay, just we have to know how to resolve these disagreements. And above all, the judiciary, the European judiciary, and I'm meaning ECJ, European Court of Human Rights, national courts as one. The European judiciary as such should not be in fight. We have to find a solution. We have to give an answer because we are the backbone of the system. We are the backbone of the system. We should not fight. So it's the substance, the one we have to resolve in a dialogue. I know might be that at the end of the day, will still not be a solution. Just at the end of the day, should be one court, which we have it now, saying what is right and what is wrong. Just how we come to that, that's a different issue. Since the charter was not only adopted, but when it started actually case law on charter and this different definitions of principles, values, etc., I think that at the end of the day, it was never the concept itself, the definition itself that resolved the case. That was my impression about the substance. Thank you.
Thank you very much. Judge O'Leary.
Thank you very much, Rick. As a judge, I never ask provocative questions. I always ask thought-provoking ones. I think it's an essential part of judicial dialogue. And quite obviously, I'm not going to engage in a discussion of EU law, which is not my competence, with Judge Rossi and with the President of the Court of Justice sitting in front of me, my point was slightly different. One thing is for the Court of Justice to identify what constitutes a general principle under Article 6, Paragraph 3. There we're talking about an autonomous concept of EU law. Another thing entirely is to identify the origins of Article 2 values or principles, whichever you prefer to call them, or to identify the sources, origins, and lodestars of the EU Charter. And there, I think the point made by a Constitutional Court judge and by a constitutional scholar is, let's not forget that there are courts who've been involved in this business for decades. And for them, the message may be somewhat stark if they're told what's a common constitutional tradition is decided by us as an autonomous exercise. Under 6.3, that's a particular exercise. I understand it perfectly. I was trained in EU law. But under Article 2, as regards the Charter, and the interplay between 2, the Charter, 6, and other provisions, I think that's a debate or a discussion worth having. So I would say, again, thought-provoking rather than provocative.
Message understood. Are there any questions, interventions, thoughts amongst the audience? We have a gentleman to the left for you. I would kindly ask you to briefly identify yourself.
Thank you. Emanuele Rebasti, another one from the Council Legal Service. And I wanted to make a remark, particularly in relation to what Judge Rossi and Judge O'Leary said on the relationship between values, rule of law in particular, and the material provision of the EU legal order and the system of remedies. And I want here to make reference to the recently adopted, well, actually 1 year ago almost, regulation for a general protection, a general mechanism of protection of the budget, so the so-called conditionality regulation. And what is really surprising, and I think that has already been referred to in the past few days, is that the very first definition of what is rule of law is not to be found in the treaty, is not to be found in the Charter, not even in a justice and home affairs instrument, but in a financial rules instrument. This regulation has been adopted according on the legal basis 322, that is the one allowing to lay down rules, financial rules for the implementation of the budget. So what has rule of law to do with the budget? And here I think that by adopting this instrument, the two co-legislators really show their understanding of the position of Article 2 in the systematic of the treaty. And as we have tried to conceptualize as a legal advisor, I think this shows that Article 2, the rule of law notion, has a structuring function for the European legal order. This, of course, is open to question, and I don't want to pose a question here because the issue is on the floor of the Court of Justice right now, exactly from that point of view. But the court will decide, but for the legislature, the choice is made so far. The structuring function of the Article 2 allows to reach out even provisions we may not have thought before as very much relevant for the implementation of the rule of law. And this is because even in the budgetary sphere, the rule of law is what underpins the mutual trust that exists between the member states. It's the mutual trust that allows them to pay into the budget, and mutual trust can only be based on equal mutual responsibility when paying out and implementing the money of the budget. And there is no mutual trust without responsibility, and there is responsibility without sharing values and the respect of fundamental principles. So I think that here the legislature has already shown an interpretation of the interplay between the rule of law, values in Article 2, and other, even far away, legal bases that we may find in the treaty.
Thank you. More an observation than a question, I would think. I see two hands raised. Lady here in the center. All this is just geographically.
Good day. I'm Katrien Witteman, judge in Holland. I have a question for Ms. O'Leary. If you can explain maybe the role which the Strasbourg Court can play in make the EU uphold its own foundational values, where do we stand when it comes to the accession of the EU to the ECHR, and what is taking it so long?
Yeah, why is it taking so long?
So we have another 13 minutes, and I think this
if we could achieve accession within 13 minutes, that would actually be good news.
I think it's a somewhat insufficient amount of time for me to answer your questions. I'll answer two of them. Judge Rossi said she would be delighted to take your questions. I'm delighted to take your questions to the extent that I can answer them. On the first point, I would give you as an example, a concrete example, of how the Strasbourg Court interacts with and articulates values in its relationship with the Court of Justice, but our relationship is with national courts, not the Court of Justice. Is Pivolaru and Moldovan, a case about a European arrest warrant, Romanian nationals in France, and execution of the arrest warrant and sending them back to Romania. I won't go into the details of the judgment, but there you see a very, I think, of course, others in the room may regard it as a judgment which is open to criticism, careful engagement with questions of EU law from the perspective of the Strasbourg Court, in which one violation and another no violation was found, and where the court engaged with the Bosphorus presumption of equivalent protection, with the development of the court's case law since Aragnosi, but finding that the French authorities, through their actions, had actually provided manifestly deficient protection. So our relationship is with national courts, but EU law feeds into the cases that we're dealing with in Strasbourg in relation to many member states, some more than others. The second question, you asked the one person in the room about accession who cannot answer your question. There are members of the Commission, Legal Service and Council here present, and I pass the ball to them. A judge, and I think other judges here in the room would also agree with me, we wait to see what the Herren Vertraga put on our table. We don't engage in negotiation processes. And in the meantime, we proceed engaging with EU law to the best we can. We follow Luxembourg judgments very, very carefully. We see that they follow our judgments very, very carefully, and that this dialogue, which perhaps there was an absence of references to the Convention for some time, as the Charter was being bedded in and found its home, has now been replaced by really a return to the good old days when there's a very careful veille juridique happening in both courts. So I'm sorry I cannot answer your second question, and nor can I predict whether I will still be at the Strasbourg Court when your question is answered.
You have a 9-year term, haven't you? A gentleman in the center.
Thank you. I'm Daniel Sarmiento from Complutense University. On the point of Article 4.2 and national identities, I found Judge Rossi's comment very interesting and her reaction as well. But I think we have to be very careful with Article 4.2 because the answer given by Judge Rossi is as it is, and is very reasonable. Member states decide what the national identities are, and EU law determines which ones work, which ones don't work in terms of adjusting them. The problem with that approach is that at the end of the day, it is EU law which sets the workable national identities and the ones that don't work. That might be the only way to make the system work, I agree. But the problem is that that will be received as a sign of unilateral interpretation of what the national identity is. And this leads us to a situation in which the perception might be that EU law determines what is its own constitutional core, Article 2. I fully agree with that. There is a constitutional core in EU law, it's in Article 2, and the Court of Justice has the last word. And then there is the risk that it's also perceived as 4.2 being a provision that allows EU law to determine what is the national identity. And that risk exists. The problem is that at the moment, in the current situation in which there are very high sensitivities in the member states and in national constitutional courts, has to be managed so carefully that I wonder if, and I very much like the expression of President Ned when she referred to being stiff, that a stiff approach towards Article 4.2 might actually create some issues. And I think that Article 4.2 is a very rich provision. It gives a very large leeway to the European Union. It refers to the duty of the Union to protect the national identities. And there are many instruments at the hands of the Union to cooperate and not to just leave as a legal issue the interpretation of 4.2. And here I refer to the Venice Commission, which I think it's an invaluable institution as such, as a working tool to help to interpret Article 4.2 and not just leave that burden on the court with the risk, I'm not saying that's what's happening, but with the risk of being misinterpreted at the national level. Thank you.
Very much. Thank you, Daniel, for this question. No, I don't think that it is up to the Court of Justice to define what is the national constitutional identity. This is, of course, the task of the National Constitutional Court. But when we are speaking of exceptions to the rules, then there must be the Court of Justice having the last word. And I want to remind that Article 4.2 must be framed in its context of Article 4. Article 4 provides other three very important principles for TU: the attribution of competencies, the equality of member states before the treaty, and the loyal cooperation. So we have to think that the National Constitutional Identity Clause must be read at the light of the other principle of Article 4. And who can do that? Only the Court of Justice. Who can accept a derogation invoked by a state in the name of its own constitution? It cannot be just a statement. This is my national constitution. Also because if we read the case law about Article 4.2, there is really sometimes very small questions, small issues. And there can be very big issues, like in BK, which was about the military activities and the application of EU directives for labor law. But in this case, you are really very sensitive point. But you know, Article 4.2 is formulated in a way that can allow a state to raise whatever issues as an issue of national constitutional identity. So I think that it is up to the court to accept that this issue that, I repeat, must be defined absolutely by the member states, by their constitutional court. But at the end, if these issues are capable to derogate, because every derogation is contrary to the equality of member states before the treaty, must take into account the attribution principle and must be made in a spirit of loyal cooperation. All these principles have only one judge, I'm sorry, in my opinion. It's the Court of Justice.
Clear. You have your preliminary ruling. A lady to the left.
Thank you very much. It was referred to, just a remark, it was referred to earlier that indeed the reference in the treaty to the fact that the Union shall respect the fundamental rights as the result from the constitutional tradition common to the member states. Of course, we all remember that it was introduced in Article F by Maastricht Treaty, and it was a codification of the case law of the court. That was the way, the first, which became Article 6. And it's the way that before we had the Charter, of course, the Union was obliged, because, of course, the article at the time was saying the Union shall respect fundamental rights as they are guaranteed by ECHR, and as a result from the constitutional tradition as general principles of community law, because it builds up on the well-known case law. An interesting thing which this archaeology of different codifications of, in the treaties of case law and also development is that the same Article F was saying at the time, the Union shall respect the national identities of its member states, and it was introduced in Maastricht. Yes, yes. The Union shall respect the national identities of its member states, whose systems of government are founded on the principles of democracy. So this addition sentence is no longer in now Article 4.2, but as you were saying, Madam Judge, indeed, they have to be read together. I mean, Article 4.2 cannot be read without Article 2, which is on the values, which is saying that these values are common to the member states in the second sentence. So but the origin of the building of these aspects is this sentence which merge the two aspects, that with the sentence, whose systems of government are founded on the principles of democracy. That's the condition for the Union to respect that. Thank you.
Absolutely, absolutely. You raised a very interesting point. We have no much time to expand on it, which is the relation between 4 and 6 TU, which is interesting, very in Pils. I think that Article 6 and the Charter regards the individual fundamental rights, while Article 4 and Article 2, actually, because rights are also mentioned in Article 2. Well, this is, in my personal opinion, more a systemic problem. Why? Because there is something in Article 2 that brings me to this conclusion. Article 2 makes reference to the societies of the member state, the societies. So I think that this can be, but I mean, this is completely theoretical. It could be the difference between the fundamental rights as mentioned by Article 2 and the fundamental rights as meant by Article 6 and by the Charter. But this is completely a professor theory.
Thank you, Judge Rossi. I see that the panel is running out of water and the room is running out of time. So we may have time just for a final message that you want to share with the audience. I start at the very left. Kees Sterk, any final remarks that you wish to make, having heard the deliberations?
Well, of course, most of the questions are about the concepts, and how the Article 6 and 47 and 19. My point is that, of course, we must discuss all these kinds of things, and that's important. That's what lawyers and judges and academics do. But we must remember the more existential feature to this discussion, that if you do not have the trust of our societies, it's all in vain.
Thank you very much, Kees Sterk. This is very good, because now every other panel member will feel compelled to have just one punchline that will also elicit an applause. So, David, the pressure is on you.
Yeah, it's my punchline. Yeah. So I will probably echo Daniel's comment that I very much like. I would just add to that I think that I know that this panel is about role of courts, but of course, in determining the EU values in the Article 2, also the other branches and the people who should take part. And on the domestic level, when defining national constitutional identity, it's not only about constitutional courts, but also about other political actors and the people. Because if we want to have a robust and resilient constitutionalism, I mean, we need sort of, constitutional patriotism, sort of attachment and internalization of the values. Because in the end, the rule of law and other values, the foundations of the rule of law and other values are political. Thank you.
Thank you. President Knets.
Thank you. I think that EC and EU always were some struggles during this path that we are on, that we are living. But I think that right now we are living an era of disintegration, unfortunately. And I would like to see that the judiciary as a whole would be the one that would end up this era, that we can give to the public, to the governments, to the legislature, to the states, and to the overall public in European Union, some clear guidances, clear vision how to go forward. This I see can be our objective, can be our task.
Thank you very much.
Thank you very much, Rick. The EU's core constitutional values clearly are to be found in Article 2, but my message was, what are the sources and origins of those values? And how should we engage with the national courts and the other European court who work daily to uphold those similar values? As regards Article 2, I think it's natural in 2021, excuse me for the frog in my throat, that we concentrate on issues of judicial independence and the rule of law. But picking up my Dutch colleague's message, the public does not understand rule of law issues. Their issues are elsewhere, and if we want to connect with what used to be called the ordinary man and woman on what used to be called the Clapham Omnibus, but in EU law terms, we might have to choose another route nowadays after Brexit, we need to engage with the other values too. Equality, solidarity. As I said, the Constitutional Convention was very clear on some of the problems which we were going to face and which we are now facing. Thank you very much.
Nice. And Judge Rossi.
Just a little sentence. The Court of Justice absolutely doesn't want to expand its power, as many scholars say. The Court of Justice just wants to defend the EU legal order. In this moment, I think that with the new tools provided for by the Lisbon Treaty and the Charter, the Court is in a good position, even if the times are very difficult. Thank you.
Thank you very much. When starting today's panel, I had to think of these television shows which are a dancing contest and where the question is which couple will survive longer standing. Luckily, we didn't end up in that scenario, which proves once more that united we stand, but divided we fall. Thank you very much for your attention.
Rick, panel members, thank you so much for your contributions. David Kozar, Geoffrey O'Leary, Lucia Serena Rossi, Raiko Knes, and Kees Sterk, and of course Rick Lawson. Thank you very much, and another applause. And maybe you've not only have inspired our honorable audience with your ideas, but also our student helpers, who perhaps at some day moderate or organize a future FIDE congresses.
I now have the honor, dear participants, to introduce to you our next speaker, the Chief European Public Prosecutor, Ms. Laura Kövesi. Ms. Kövesi was Romania's first woman and youngest general prosecutor ever. She received praise within Romania and beyond in her role as head of the National Anti-Corruption Directorate. It doesn't surprise then that she was prescribed as the bravest and most distinguished candidate to head the newly established Public Prosecutor's Office. And indeed, in 2019, she was confirmed as the EU's first Chief European Public Prosecutor. The EPPO is not only a decisive next step in the protection of the financial interests of the European Union, but certainly also in EU criminal law and for European integration at large. Ms. Kövesi, we thank you for being here, for having joined us in person. We know you have an incredibly busy schedule. The floor is yours. Thank you for being here.
Good morning. Thank you very much for this nice introduction. Now I'm a little bit nervous because I know that the level of expectations is higher than usual, but I will try to do my best. Ladies and gentlemen, I'm very honored to be here with you today and to share with you a few ideas about the European Public Prosecutor Office. A dear friend, a fellow prosecutor, once told me that he never doubted that things will always eventually turn out well with law on his side. My friend is by nature an optimistic person, but I get his point. The law not only guides us as to what is right, it also gives us courage to do what is right. Justice is the very core of what allows us to live in society. There can be no community in Europe that is not a community of law. There can be no union in Europe without the rule of law. As law practitioners, we are in the first line of defense of the fundamental values and principles on which our union is based. This is why the establishment of the European Public Prosecutor's Office is of strategic importance for European integration. As European Chief Prosecutor, I met many people who misunderstand the EPPO as just another agency of the EU. I also met many people who consider the EPPO as a pilot project, a proof of concept, something small, which, if it works, might eventually be scaled up. Well, for me, the reality of the EPPO is quite different. First, institutionally, the EPPO is an independent organ of the European judiciary, not an agency that typically executes or coordinates a policy defined by a political authority. We are not a coordinator. We are not a network. We are not a new layer to improve cross-border cooperation in judicial matters. Our competence is a genuine transfer of sovereignty. We are a specialized prosecution office, independent from the respective national authorities. Our European delegated prosecutors are embedded in the respective national systems with full prosecutorial powers. Any crime falling under our competence, as defined in the EPPO regulation, has to be reported to us. Only the EPPO can investigate, prosecute, and bring it to judgment in the relevant national court. The EPPO is a systemic part of the overall architecture put in place by the EU to protect its financial interests. It seems that not everyone has fully grasped the systemic nature of the EPPO. If you are obstructing the exercise of our competence, the protection of EU budget is at stake. As we operate, we are identifying a whole set of issues related to the application of 22 different criminal laws and criminal procedural laws, as well as to different implementations of the PIF directive. The most evident legal challenges that we have and that we will continue to have in the years to come are linked to our structure, competence, and the absence of an harmonized criminal law and criminal procedural law. We need to work as a single office in 22 different legal systems. How to ensure a common approach and consistency between so many different legislations, legal traditions, jurisprudence, operational and organizational structures? It is evident that our work will generate new groundbreaking jurisprudence by the European Court of Justice. It will also have an impact on the daily work of our fellow prosecutors, judges, and police officers in the member states. Second, we are not the outcome of a small transfer of competencies. As from 1st June this year, we have started operations. We have processed almost 2,400 criminal reports, initiated more than 400 investigations for an estimated damage of more than 5 billion euros. This should not come as a surprise. In fact, it is only the beginning, the tip of the iceberg. We are getting all the workload that was until now dealt with at national level. The transfer of existing cases on which we have to decide whether we keep them or return to the national authorities has not been completed yet, and simultaneously we are dealing with all the new cases. We are getting this workload for a reason. In line with the principle of subsidiarity, we are supposed to be able to deal with it more efficiently than the national authorities. Let me explain why. I am convinced that the EPPO is changing the paradigm of cross-border investigations involving organized crime and financial fraud in the EU. We are investigating fraud involving EU funds of over 10,000 euros and cross-border VAT frauds involving damage above 10 million euro. we are responsible for fraud happening on both sides of the EU budget, expenditures as well as revenues. It is evident, in particular, when it comes to cross-border corruption or VAT fraud, that our main adversaries are organized criminal groups. This is why our prosecutorial policy is to focus on those cases where serious organized crime is involved, and our main objective is to help member states recover the damages. The greatest advantage of the EPPO from an operational point of view is that we act as a single office within a decentralized structure, where until now any prosecutor had to use the lengthy channels of mutual legal assistance to get information or evidence from another member state. The European delegated prosecutors cooperate directly. A phone call, an instruction in the EPPO's case management systems are enough. We also have the ability to merge investigations and prosecutions across borders. This allows to proceed much faster in individual cases, but it also allows to discover new criminal activities and open new investigations based on information that no one else can have. No one is currently better placed than the EPPO to investigate all the possible ramifications of cross-border cases. The immediate access to all the information in the cases registered in 22 member states allows us to establish connections that could not be identified otherwise. In fact, we have unprecedented access to all the available databases and to international facilitators such as CARIN, Interpol, the Egmont Group, and the FIUs. A close cooperation with Europol, OLAF, and Eurojust might be established from the initial stages of any of our investigations. Over time, I expect that we will have more and more investigations that could simply not have been initiated at national level because no one would have picked up the relevant information. With the establishment of the EPPO, we have created what I call the EPPO zone, a zone where by implementing a prosecutorial policy, we are unifying the approach to EU fraud investigations, a zone where we think and act functionally rather than internationally. To give you a concrete example, we are not asking national authorities to put more focus on custom fraud. We are the authority bringing all the relevant actors in the EPPO zone, be it in Rotterdam or in Valletta, to improve in this way the level of detection of custom frauds. Ladies and gentlemen, the operational start of the EPPO has taken place in a context no one could anticipate. The overall volume of the financial interest of the EU has almost doubled, and we will have new own resources. The COVID pandemic has already weakened the economic system and made it more vulnerable to criminal infiltration. The risk of corruption has increased. There is no precedent for a European Public Prosecutor Office. Our main aim is to make a real difference on those cases where serious organized criminality is involved and to help the member states recover more damages. It is not easy to find solutions for 22 different judicial systems. Each of us comes with a specific background, language, culture, but we have to act as one team. Our workflows and procedures are complex because we have a complex structure. Between the central office in Luxembourg and all the other decentralized offices, we have to create a sense of belonging and collective identity. But our potential outweighs the difficulties. I trust that together we will make this self-evident, so that very soon law students in Europe can only wonder how come it took us so long to make EPPO happen. Thank you very much for your attention.
Thank you so much, Ms. Kövesi. And thank you for this lucid insight in the nature, the potential, and the complexity of the EPPO. And we have a few law students here, and I've been teaching them about the EPPO. And indeed, I hope that in 10, 20 years, indeed, they will be wondering why it was ever different. But I can only imagine to begin to imagine the amount of work and challenges still ahead of you. But thank you for joining us here today. And that brings me to the next traditional feature of the closing morning, and that is the presentation of what will be the 30th Congress, the FIDE Congress. I see some enthusiasm already in the room. The presentation of the Bulgarian candidacy for the FIDE Congress. Judge Arovayev, I understood that there will be a video first and that then you will take the floor. So I would say sit back and relax and enjoy the video.
Dear colleagues and friends, it is a great honor and a pleasure to address you in my capacity of President of the Executive Committee of the Bulgarian Association of European Law on the occasion of the next 30th FIDE Congress. While the last minutes of the Hague Congress are ticking out, and we are still looking for the right ways and words to express our gratefulness and appreciation to our Dutch colleagues for the moral and intellectual confidence and courage they gave evidence of during an unusually long and difficult period. I now invite you to turn your eyes diagonally to the southeast of Europe, where Sofia, the capital of Bulgaria, lies, and where in less than 2 years the next FIDE Congress will take place. Bulgaria, being one of the oldest countries in Europe, rich of history and of different cultural traditions and historic heritage, it is at the same time one of the newest members of the European Union.
Follow us into the heart of Bulgaria and discover an ancient city, the city which will welcome you with open arms, Sofia. You will find yourself at the crossroads where East meets West, where history has left a visible mark that today makes Sofia a beautiful melange of ancient ruins, architectural masterpieces, and modern structures, where the sun's rays cover the picturesque golden brick streets of the city and its red rooftops, and reflects off the golden domes of our cathedrals. Nestled at the foot of the Vitosha Mountains, Sofia is one of the greenest cities you can visit, and behind every corner you can stumble upon hidden treasures. And because it's the people who make the place, we believe that, united, we stand strong. We keep our faith in kindness and tolerance. Our capital is the only place in Europe that has places of worship for 4 major religions just across the street from one another. We work hard and strive to constantly improve and preserve the past for new generations. Here you will find that the people do not know the meaning of biofood. For us, it is simply food. You will meet a lot of friendly faces who will gladly share the secrets and mystery of the Bulgarian spirit with you. Here a yes might mean no, and no might mean yes. But it is not our intention to confuse you. We're just eager to get to know you. Today, Sofia has become not only an attractive tourist destination, but an attractive Congress one as well. The city offers 5-star accommodation and services, and multiple venue options. We're happy to share the fastest internet in Europe with you. The National Palace of Culture is an award-winning Congress Center. Folks say that a woman bearing the name Sofia lived here with her 3 daughters, Faith, Hope and Love. 3 of the values that the people here strongly believe in. So join us on an adventure. Sofia will charm you with its assorted flavors, its cheerful and joyous spirit.
The Bulgarian Association of European Law, established shortly after the country's accession to the European Union, our association has dedicated all its efforts to the development and shaping of European legal culture in our country, in line with one of the main objectives of FIDE.
The Bulgarian Association publishes since 2011 the first and the only Bulgarian journal dedicated entirely to European law, containing insightful legal analysis of the most significant judgments of the court and landmark developments of EU legal framework.
Some important judgments of the Court of Justice of the European Union originated from Bulgarian jurisdictions.
The statistics still shows that the Bulgarian jurisdictions represent a regular and competent interlocutor of the Court of Justice.
Das FIDE-Seminar muss für die Jugend inklusiv und offen sein. Das ist eines der Prioritäten des Kongresses sein.
Qu'est-ce que l'Union européenne pour vous?
The future.
L'UE, c'est la jeunesse, la fraternité.
Den gemeinsamen Werten.
Multiculturales Raum.
The EU is freedom.
Diversity.
Европа е младата надежда.
I have to admit that over the last decade or so, the European Union has been battling one crisis after another. We really haven't had the time to stop and think about the future of the European legal order. Today, more than ever before, the Union needs to define its direction. I am confident that the FIDE Congress in Bulgaria will help us all find that direction.
We are delighted and eager to welcome you in Sofia. Do not miss this opportunity to visit our beautiful city.
Dear colleagues, I add some words to this presentation, just to say that it's not just a tourist invitation. I have some problems with the light. While we still stand together in solidarity with our Dutch friends, instead of mere sympathy, I would address my first observation concerning the high level at which this Congress was held. And I assure you that the Congress, which was a real success, has provoked a desire in the Bulgarian Association of European Law to replicate this success, at the next 30th Congress of FIDE in 2023. In the light of what we have heard these last 3 days, including this morning, and I would say including Ms. Kövesi's presentation, and I would even add the address last night of the Dutch Minister on Foreign Trade, we have the ambition, the intention to ensure continuity in the conceptual framework within which the developments of EU law have been addressed these last 3 days. The European Union, as pointed out this morning also, has been dealing with one crisis after the other over the last decade or so. And you know, the sovereign debt crisis, Brexit, the pandemic, the soaring energy prices, etc. Overwhelmed by the urgency and the gravity of these crises, we haven't had the time to stop and reflect on the future of the European legal order and the way we would like to evolve, we'd like it to evolve for the future generations. The next Congress in Sofia has the ambition to focus on the strategic development and the future of the Union, generating new propositions and ideas. It will be, in our ambition, a visionary Congress. At the heart of it lies our objective to focus on the constitutional identity of the European Union, its economic model and its social dimension. While like all FIDE congresses, the Congress in Sofia will unfold around three main topics. They are all united in one common thread, defining the constitutional, economic, and social physiognomy of the Union. The importance of the first topic, mutual trust, mutual recognition, and the rule of law, can hardly be overstated. Mutual trust, mutual recognition, and the rule of law have evolved to become cornerstones of the European legal order. This topic aims to shift the debate from focusing on events in certain member states to wider conceptual and constitutional questions. It thus has the overarching aim to examine whether these principles are capable of forming the very backbone of the constitutional identity of the Union and therefore become the foundation of the full spectrum of EU law. On a more specific basis, new developments will also be discussed, such as the economic consequences of the deficiencies of the rule of law, like the new mechanism mentioned this morning, I think, of conditionality for the protection of union budget in the cases of breaches of the principles of the rule of law. More importantly, the debate has so far been mostly structured on a top-down approach, that is to say, the mechanisms that EU institutions have at their disposal in order to examine compliance with the principles of mutual trust, mutual recognition, and the rule of law on the national level. The topic will expand the debate by examining its horizontal dimension. That is, the way national courts examine the deficiencies of the rule of law in their own member states, as well as other member states in the European Union, in the context of applying the various instruments of judicial cooperation. It will also discuss the often underestimated bottom-up dimension of the debate. That is to say, how breaches of these principles on the national level can have consequences on the Union itself by eroding its own constitutional identity. The second topic, the new geopolitical dimensions of the EU competition and trade policies, is fast becoming the new hot topic in EU economic law. It is the focal point of several different branches of law, competition law, trade law, and investment law, though the prism of industrial policy with the objective to achieve the strategic economic autonomy of the Union through the prism of industrial policy. At a time when EU competition and trade policy is being redefined with the objective to support a green and digital recovery and to promote investment in key sectors, some key notions may need to be revisited in order to take into account the new realities. Issues such as European champions or the lack thereof, killer acquisitions, security concerns linked to foreign direct investment, foreign subsidies, and the securing of strategic value chains will inevitably be discussed. For example, it may be necessary to consider what forms of strategic cooperation in sustainability initiatives or in securing the autonomy of strategic value chains are possible without infringing Article 101, paragraph 1, or are capable of being justified under Article 101, paragraph 3 of the Treaty on the Functioning of the European Union. This logic will also provide us with the opportunity to discuss if new economic constitutionalism is likely to emerge, a concept which reflects a constitutional shift in the EU integration process. Thus, the elements of a new political economy of the Union could be outlined. In the context and on this basis, the Union will be in a position to shape the world around it through leadership which reflects its strategic interests and values. The third topic is entitled European Social Union. The purpose of this topic is to discuss the development and strengthening of a true and meaningful EU social dimension. It is often thought that while European economic integration leads the way in European affairs, social coherence and social integration often lag behind. The topic thus aims at conceptualizing the idea of a European social union as a way of bringing the EU closer to its citizens. It will address a number of issues, amongst which feature specifically the following: conflicts between free movement rights and social rights, the importance of the charter-based solidarity rights, the impact of the movement, the impact of free movement on the demographic crisis, and the adjacent brain drain phenomenon, which has ravaged Eastern and Central Europe, as well as parts of Southern Europe. EU trade policy and labor rights protection, social justice and solidarity as common values of the Union. As you can see, this brings us to another central tenet of European integration, the principle of solidarity as an integral part of the constitutional identity of the Union. En d'autres termes, notre analyse risque de rester incomplète.
Our analysis, in other words, risks remaining incomplete when it comes to these principles and these values, unless we stand up for those values, those common values for the European Union member states and their citizens. Which reflects the social dimension of the European construct and which covers several elements, be they social freedom of movement, social security of migrant workers, access to social benefits for member state nationals, says the speaker, for third country nationals during long-term stays in the Union, and the granting of international protection, the effects on solidarity of competition rules and state aid rules, but also on the Union's external action and so on.
Infiltration of values and principles between different areas of Union's legal order is a characteristic feature of this order and of the Union itself, and of a constitutional identity, and of its constitutional identity, which has evolved, as rightly observed, from a community of law to a union of values. For our part, we hope that the analytical framework which will emerge at the FIDE Congress in Sofia will help national and EU institutions to envisage and eventually build an ever closer and a stronger union. We are looking forward to welcoming you in Sofia in May 2023. Thank you.
Thank you so much. And I, for one, am very excited to be going from a founding member state to a one of the newest member states in 2023. And let's hope that it will be in 2023, but because we have experienced that there's only so few certainties in life. And fascinating topics. I must congratulate you already on the choice of those. I think many of them actually pick up on issues identified here already, and many that will no doubt remain on the top of our academic and political and judicial agendas for the time to be. Without much further ado, I think this is the moment where I hand over the floor to the President of the European Court of Justice, Koen Lenaerts, for some final words. Thank you so much.
Thank you. Thank you, Jorrit. Well, the organizers have invited me to share with you a few final feelings about this conference. And I really call it that way because I want to share three with you. And those feelings came up while participating, maybe too actively at some points, in the sessions of this conference. First of all, I was impressed by the fact that FIDE remains a very successful formula for meeting between professionals from all backgrounds, from all over Europe, based on strong national reports, based on comparative law method. And it reminded me of a speech given by Justice Stephen Breyer when the Supreme Court of the United States paid its last visit a few years ago to the Court of Justice of the European Union in Luxembourg. And Breyer spoke before a big group of referendaires and civil servants working on the law of the European Union. And he said, in my view, in the United States, the law develops in an interaction between the bar, the bench, and academia. And that's, I think, also here inherent in the success formula of the FIDE congresses. We have lawyers or agents from member states, from institutions, from private practice. We have academics, some mix the two capacities. We have judges from the Court of Justice, the General Court, but also, very importantly, from national courts. And for instance, yesterday I was sitting in the first working group, there was a judge saying, yes, but all this thing about mutual trust, mutual recognition, that's all very interesting at the conceptual level, but I mean in actual practice, I have all these possible criminals in this border region between two member states, and I must come to terms with that phenomenon without there being organized impunity. So I think that is really the added value of FIDE, to have the bar, the bench, and the academia interacting critically. And the second point is, like Peter van Kleinenbreugel said this morning, we agreed to disagree. And that's also very important. We must always look to asking the right questions. But we can't set to ourselves the ambition to always have the one conclusive, correct answer. Law remains a dialectic process, and the answers may remain open. But there is one exception, and that is the core values of Article 2. And I say the core values, all of them, not just the rule of law. There are also many other values, and Judge Shifra O'Leary very rightly this morning reminded us of that. The study just quoted, and I thank Judge Arabajiev on solidarity, is in my view a core value. Without solidarity between richer and poorer member states, between West and East, between North and South, and this whether it be migration or social union, a very welcome topic for the Sofia FIDE conference, the union cannot survive. It's not with "I want my money backs" that the union can survive. Never forget that it all started with the Schuman Declaration, l'Europe ne se fera pas d'un seul coup, ni dans une construction d'ensemble, mais par des réalisations concrètes, créant d'abord une solidarité de fait. So all these values on which the Union is founded, they should indeed be brought to the citizens, to civil society. That's where the role of education comes in. Europe cannot survive when young citizens are not being educated. Educated to become citizens, understanding the system in which they live. And the system in which they live is a state which is a member of a broader ensemble, being the European Union, with its own constitutional identity, which is laid down in Article 2 and in the Charter of Fundamental Rights. Now, here, you know, my field of academic expertise is comparative constitutional law, in particular with the US constitutional system. And as a small addition, just this. When on the 17th of September, 1787, the Federal Convention in Philadelphia was ready with the US Constitution, there was no Bill of Rights attached to it. No Charter of Fundamental Rights either. Lasted a long time. It lasted less long in the United States. During the ratification conventions in the 13 states, it became quickly clear that without the addition of a Bill of Rights, there would not have been a chance to have that constitution, which was basically a treaty between the 13 states, ratified in all of the state legislatures. The idea being, it was mentioned here this morning in the excellent debate, that the states could not surrender competences to a federal government without being sure that the same constitutional guarantees which they had in their state constitutions would also be valid at the federal level. So the Bill of Rights was added, the first 10 amendments. But then member states were not so faithful. The states were not so faithful to the common values. It even led to a civil war. Do not forget that, to a civil war, 1861 to 1865. And then 5 further amendments were added in 1865, including the very important 14th Amendment with its due process clause, life, liberty and property, protection and equality before the law. And then gradually the Supreme Court started incorporating the federal fundamental rights, the Bill of Rights, into these amendments which were opposable to the states, to hold the states to the common standards. Well, dear friends, throughout this conference, I thought very often to that phenomenon. Of course, the member states wanted these common values. They even say in Article 2 that they share them. Do not forget that. They recognize that these values are common to them. And the Charter of Fundamental Rights was added like the Bill of Rights in the United States. But now, the federal level, the EU level, must make sure that what has been brought in common as values and fundamental rights protection remains common. What do you think when you follow the US news? The Federal Supreme Court pronouncing on the Texas law on abortion. That's federal standards for an exercise of state competence. We are now in a similar development, fortunately not after a civil war, fortunately not by sending the Federal Guard, what President Eisenhower had to do to Tennessee after the Brown versus Board of Education judgment, the desegregation judgment. We use other means, but these means are political means. The Commission must play its role. All the member states vis-à-vis one another must play their roles in order to see to it that the judgments upholding the values of Article 2 are being faithfully complied with everyone. And I stress with everyone. There are no good fellows and bad fellows in this story. All member states have to live up to the common standards. Last point is heartfelt thanks to the Dutch organizers of this FIDE Congress. It was a remarkable, I would say, a resounding success in all respects, in terms of organization, fluidity of organization, quality of the catering. That's very important. I'm a Belgian after all. It's very, very important. But especially the level and the quality of all what has been said here, exchanged here. It was a perfect choice of subjects, even maybe more timely now than when it was initially planned. It has been said already. And almost sowing the seeds for the further reflection in 1.5 years already in Sofia. I feel here on the bridge between two Fides. So I conclude with heartfelt thanks to Corina and her team, and with all warm wishes for success to Sasho Arabadziev and his team. Thank you.
Thank you so much. Dankjewel, Koen. Thank you, President. Thank you for your personal reflections. And now that we're talking about catering, actually, before I do my closing statement, please bear with me and allow me to have some household announcements. When we will be leaving the room afterwards, there will be lunch. It is maybe not as extensive as before. It's a grab-and-go lunch, so you can stay here and eat it here, or you can take it with you when you go to your car, your plane, the train, or whatever. So that is the first. Now, while you're going to take your grab-and-go lunch, you're welcome to visit once more the exhibition room. We're used to the digital economy. We've been talking about that a lot. We're used to digital life, but we're all lawyers and we love books, paper books, and there's still some out there. And because it's very expensive to send them back home, especially the publisher Nomos has offered that we can just take the books that we like and take them home. And actually, we also have some books on topics 2 and topics 3 that you are welcome to take with you. I must admit, topic 1 has been finished already. Then the last announcement is the recording. It's been mentioned before. The plenary sessions of Thursday morning and of today, they have been recorded on video. There will be some light editing, and then we hope that we can put them online by the end of next week. I think Monday is too ambitious. I think that we will take a few days off, and even our Congress organizers will do that, but by the end of next week, most likely. Then the working group sessions have been recorded by audio, and they also will be put online on the website, and we will inform you, so that everybody can re-listen, re-look at it, and also those sessions that you haven't been able to manage, you can follow them, or maybe as a podcast while you're walking. So now let me come to my final closing statement. Our Congress is drawing to a close, and at the opening session, I recalled the importance of us European lawyers of taking our task serious and continue the discussion, listen to each other, try to understand each other, and also be able to, what indeed Koen Leenaerts just said, be able to agree to disagree, but to continue the debate. The discussions have been numerous. They have been really interesting, topical, very inspiring, and sometimes very difficult. It's very comforting to know that this closing session is actually not a closing. It's the opening for the continuation in our 1.5 year. And we have heard the topics that will be dealt with then, and it's true, it's been said before, but we will just continue, and we will have to deal with our national working groups and rapporteurs and start working quickly on them. So it's actually not even waiting 1.5 years. We will be starting that in January, probably next year. Il me reste à remercier. I have to thank a lot of people.
So I'd like to thank all the reporters, the institutional reporters, and the national rapporteur for their excellent work, for the preparatory work during the 2 previous years before the original date of May 2020. It was already extraordinary what they'd done, but even during the follow-up period of 1.5 years, they really have undertaken an enormous piece of work in order to bring up to date all of the reports and make sure that all the information is absolutely up to date. In addition, I want to express my admiration for the moderators. They were excellent, without exception. I was here for topic 1, but everyone said to me that upstairs, and here next door, Jorrit said it was excellent everywhere. So we're very proud of what people have managed to do. The moderators, the rapporteur, the general level, institutional level, the national level.
To take up the role of a general moderator at FIDE. I think it's incredibly difficult. I would also like to thank the speakers of Thursday. I mean, they're not here, but especially the Thursday morning panel Fit for the Future. As David Kozar said this morning, we really need to leave our bubbles. We are living in this EU law bubble these past coming days, and it feels very comfortable. But we need to leave our bubbles and talk to the other bubbles. And so we did try to do that with a panel with non-legal thinkers, economists, historian, philosopher, etc. And I think that that was very inspiring. So I really hope that that is a tradition that we will continue in FIDE. But I also want to thank the speakers of this morning and the panel, especially of this morning, which was very impressive. And I would like to thank them for their openness as well. those attending topic 1, the first morning, they may recall the message that Anna Wallerman, the acting rapporteur, had read from Michael Duggan. And he so nicely said, well, I wish you very inspiring days and discussions, and I trust that you will have solved all the problems by Saturday. Well, we know that that is not the case, and especially not when we think about all the subjects like mutual trust, the rule of law, etc. And I'm really glad that we will continue this discussion in 1.5 years. So then, finally, I would like to restate that FIDE and the Court of Justice have a very special relationship. And we are grateful and honored for the support given by the court, the General Court, its members, while preparing, and we've been preparing for 8 years or something. We've visited the court, we've spoken to various members to discuss our ideas and to verify whether they agree with them, and then to rediscuss, etc. And it has been really valuable, so we thank you for that. But we thank you also for your flexibility. This has been very important to our team. But then, of course, with all these thank yous, zum Schluss, ich möchte auch.
Oh yes, and also I want to thank the translators and the interpreters. They always do extraordinary work. And of course, it makes communication between us possible. And also to thank our sponsors. And of course, I want to thank you in the room, everyone who sit here, because without you being here, it wouldn't have been possible. But also I want to thank the upcoming generation, the new generation, the young generation, who is responsible for the Young FIDE event, for the young rapporteur, who have also sat at the tables with us and have given such good work, and also the young European lawyers, who are even younger, who were responsible for a wonderful evening on Thursday evening.
Goes to the FIDE team, and I really want them to come here. It's almost an emotional thing because we've become really family. It's been such a long time. 8 years, 9 years, I can't even remember. We started the idea in Tallinn, and I think we were all drunk when we did that. We were sitting, or maybe having the hangover the next day. I remember sitting in the plane, and I had to write a pleading notes for a court hearing. I wasn't aged at that time. And then there was this idea, like coming, well, we should take it to Holland. And I was just president of the Dutch Association for European Law, and I said, okay, shut up, I want to write my pleading notes. And this is how it went. And it's been a really bumpy road. It was a nightmare at times, really. But it's also been a lot of fun. And I think that that is the most important one. Humor is very important in life, in personal life, but when you organize a congress like FIDE, it's essential. Without that, it's really impossible. So let me really take the smaller FIDE team with Jorrit Rijpma, who has been really important as sort of the most responsible for the academic part of it. Please come here, because I have asked the students to bring here the flowers. Marlies Noord, the treasurer. Herman van Harte, Marleen Botman, Clara van Dam, but then I also want to mention Charlotte Schillemans. She's a general secretary for FIDE, because we then also held the presidency. And I think she's been very visible for all the members of the comité directeur. So Charlotte, I'm not sure whether we still have flowers for you. We do have. And Armin Kuivers, I'm not sure where he is, but oh yes, please, Armin, he's the treasurer of the FIDE. He was very important as well, and we do have flowers for you. So. Now I realize I have a problem because I have one bunch of flowers. No, I don't have, but they will, okay. Because these are for Carina van Os, our student officer. I don't know where she is, whether she's here. She's been the chef of all the students here, and she's been extremely valuable. I think that's it. I'm just really glad it's over, actually. But thank you so much.